For delivery of judgment, item 15 to 17.
Wow. Precisely for this reason, we have found that the principal Jorhat Engineering College communicated to the appellant that from the retrospective date of promotion till the date of his superannuation on 31/3/2022, he would perhaps be entitled for financial benefits, but only when the relevant payslip is received in the office of the principal of Jorhat Engineering College. True it is that if a promotion is not effected, as was in the case of respondent number 1, Dr. Amal Satpathy, in a different case, in Government of West Bengal and others versus Dr. Amal Satpathy and others, he was also not held to be entitled to any retrospective financial benefits associated with the promotional post of Chief Scientific Officer, as he did not serve in that capacity. But the same principle would not apply proprio vigor in the case of the appellant herein, who was the in charge principal and was promoted specifically with retrospective date by the notification issued post his retirement, which in turn was based on a scheme, and only after it was found that he fulfilled the criteria. Thus, in our estimation, the appellant would be entitled for only the financial benefits of the higher post of professor from 17/5/2018, that is the notional date from which he was promoted, till the date of his superannuation on 31/3/2022. However, since the order of promotion lapsed with the recall of the office memorandum dated 28/3/2022, he shall be deemed to have retired as an associate professor, and his pension would be fixed on the salary of associate professor which he had been getting. We thus order accordingly. The judgment impugned is thus modified to the extent by clarifying that the appellant would only be entitled for financial benefits associated with the post of professor from 17/5/2018 to 31/3/2022 and no further. The appeals stand allowed to the extent.
I agree.
Item 18.
The grounds taken by the petitioner are not sustainable. However, we therefore, while concluding, direct that all such directions issued by the tribunal with respect to salary and transfer allowances and grants as admissible to the petitioner be paid to him forthwith, preferably within a period of 3 weeks from today. The writ petition is but dismissed, making it cost easy.
I
Adjournment request, if any, from item number 1 to 6.
Please, my lord. With the consent of the petitioner, my lord, I beg to mention item number 4, my lord.
And number 4,
Yes.
adjournment slip has been circulated.
4 and
4 and
5.
5 together. Yes.
Yes, my lord.
All right, January, February, wherever it is.
Obliged.
4th February.
With the consent of the petitioner, I beg to mention item number 6 and 7, my lord.
You have circulated the adjournments.
Yes.
All right.
Obliged.
5th February. 5-2. Item number 8 to 14, adjournment request.
May it please, your lordships, I beg to mention item number 9, lordship.
All right.
Obliged.
Adjournment slip.
5 February.
May it please your lordship, with the consent of the other side lordship, I beg to mention item number 21 and 22 of today's list lordship. On last occasion, lordship has observed something lordship regarding the PF scheme of tea estates in different states of India lordship. We have not found anything because only the Assam plantation PF scheme is there only. But we have some other that means schemes we have.
No, what do you want?
Lordship, we want some time to go through this and appraise your lordship.
This is item number 21.
21 and 22, lordship, supplementary item hearing.
You are for the respondent.
Lordship, I am for the respondents.
27 January.
As prayed for. on behalf of respondent state and agreed to by the council for the this is appeal, no? Council for the petitioner.
Petition,
Let this matter come up for consideration on-
27 to 28th, my lord, in January. 27 to 28th, any,
of
January.
For January.
Yes,
27th.
Obliged, your
Let-
lordship.
Any other request? Daily list for admission item 1.
Deputy Commissioner has filed an affidavit saying that only 60 acres of lands are occupation by the sericulture department.
yes.
So therefore, as per the law, my lord, the sericulture, the archaeological department is liable to maintain the monuments. So accordingly, my lord, your lordship, whenever they give the land, my lord, it has to be maintained by the archaeological department.
I didn't follow. What are you saying?
My lord, they have filed an affidavit
Yes,
saying that, my lord, out of 120 acres of land, 60 acres of land is in occupation of the sericulture department.
and sericulture was,
They are willing to give up.
they,
it up.
they would have, they would go out of that place if the Archaeological Survey of India says that it is within the protected monument.
Yeah.
Is this the position?
We are there from 19.
That's true, but then if it is protected place, I think you'll have to go. That's the law. So therefore, what does ASI say?
Yes,
Uh,
they are.
We have filed an affidavit on 9th of this month, lordship. And our stand is that only the archaeological, the sericulture department is there. lordship.
No, what do you want? I mean, do you want this?
No,
I mean, the
land has
purpose
to be-
is sericulture department, they are doing some work. That's
No.
that's not for private
No, It's
purpose.
a protected place, lordship, that we have to take care of. So once it is vacated, lordship, that has to be taken up by us.
What do you say to?
But thing is that panel,
No, have you taken instructions with respect to vacating that premises?
vacating this part panel, I will take the. Otherwise, we have taken that from 1997. We have
followed that. We have followed that, but can it be done? That's the question. It
All
can't be
along
done.
their stand is that we will vacate it because
Take your,
It is a protected-
take your instructions, come back to us. You tell us by what time would you relocate? Because you have been running for last, I don't know how many years, more than 60 years. So, but this has to be protected. Because ASI rules.
In fact, pilot, we kept it protected panel. Although pilot archaeological, they were nowhere.
No, then we have to take a call. You have to relocate somewhere else. Take instructions and then get back to us. Take them. Pursuant to the order dated 29/8/2025, an affidavit has been filed. Affidavit on behalf of?
I filed on behalf of respondent 2 and 4, that is archaeology.
An affidavit has been filed on behalf of respondent number 2 to 4, 2 and 4. You have filed the affidavit on behalf of respondents number 2 and 4. The report, the affidavit indicates that 60 acres of land is under the occupation of sericulture department, but the same is within the protected area of the protected monuments. Stop. There is no dispute with respect to this factual assertion. Stop. In that case, the sericulture department will have to be relocated. Stop. Mr. His name?
Mr. Dhar.
Mr. Dhar, learned advocate appearing for ASI, submits that he shall take Huh? For sericulture. For sericulture, what is sericulture is the department. For so and so, Mr. Dhar, learned advocate appearing for so and so, submits that he shall take necessary instructions and shall get back to this court as to how, as to what time would be taken by them to relocate their entire establishment to any place which is outside the outside the protected area of the archaeological monuments, of the monuments, of the protected monuments, January.
30th January. 30. Item 2,
Boiler authority. He's got. He's got. Mr. Gaur, you don't have a case. Somehow the other, unfortunately, you could not upload any certificate.
My lord, just have a look at page 2 of my friend, what the documents my friend has submitted, my lord.
Yes.
My lord, here, in the middle, there is a one apprenticeship number, my lord.
In the middle?
In the middle of page 2, my lord,
Yes.
there is one apprenticeship number, then my lord, apprenticeship company. Apprenticeship company is Indian Oil Corporation, my lord. Above it, the apprenticeship number is there, my lord.
That's true, but then this number, unless you annex the
My lord,
certificate.
my lord, this number belongs to, my lord, the certificate issued by National Apprenticeship.
That's right.
Yeah, no.
Absolutely correct.
My lord.
But then it is a mistake on your part. It couldn't be uploaded.
No, my lord, I have uploaded it, my lord, your lordship may, I have my appellant is here, my lord. He has uploaded from his laptop, my lord. Your lordship may send this laptop to any expert body, my lord. They can verify whether he has uploaded or
They did, I'm assuming that you did it,
Well-
they never received it. You're right,
Well-
Mr. Gaur. They should have intimated that you have given the number, but this is missing. And there could be some problem in such online filing of certificates. There could be, but then you have missed the bus. Now, how can it be done? Everybody has been appointed.
No, my lord, I have uploaded whether they get it or not, it is, I'm not sure, my lord. No, my lord will say, my lord,
The
that,
communication is
no,
complete
my lord,
only.
my lord, this, they said that this is a blank page, my lord. My lord, my certificate has been endorsed in the 2021, my lord. My lord, if I have loaded the first page of it, my lord, why I will not load the
That's
back?
right. That's right. We can understand your bona fides. We can understand your bona fides, no
My lord.
difficulty. There was, if you had the document, why would you not do it?
My lord,
But for the communication channel playing truant, you could not get it. But did you have a receipt of all uploading?
my lord,
Can you
my lord,
provide a
my
receipt
lord,
of all uploading?
my lord, prior to this Indian Oil Corporation, there was similar advertisement from Newligate Refinery, my lord. And he has made a folder, my lord, in their 2023, my lord. That folder, while applying,
What can be done? All the posts are filled. Now somebody will have to be elbowed out. You, of course, performed very well.
no, my
You
lord.
got
No,
67
my
or
lord,
something.
my lord, then, my lord, my lord, the terms and conditions as set out in the advertisement, my lord. If, my lord, these are applicable to me, my lord, equally they are applicable to the respondent also, my lord. My lord, just have a look, my lord, at their own, my lord, this. My lord, my
I
lord,
think you'll have to give some certification that you had uploaded, they didn't
my
get
lord,
it.
I am giving my laptop, my lord, lordship may send it to any.
That we are
expert.
not going to do in this
So, my lord,
jurisdiction.
then, my lord, the respondent has submitted these documents, my lord. Many of these documents are, my lord, vacant, so blank, my lord. Now, they said, my lord, that they could not get it downloaded, my lord. So, getting it downloaded is not on my part, my lord. If something has happened in between, my lord, uploading and downloading, I cannot be made responsible, my lord.
You have filled up all posts.
No, my lord.
These
Result, my lord, so far this.
This post is vacant, madam,
This post is vacant.
because there were two petitions,
Why
madam.
did you consider his application?
Madam, it will be difficult, madam, because the other case also, admittedly, he had not uploaded the second page
No,
of
no,
the
no.
certificate.
See, did you tell him that this is the number, but there is no corresponding document? You never
No, my lord,
corresponded.
my lordship, he has cited the number. That number is available in the certificate which he has uploaded, my lord. Kindly see that flag mark portion, my lord. The number he is referring to is available in the certificate he has uploaded. In the second line, my lord. That is the contract number.
Hmm.
That per se is not proof that he has uploaded the actual certificate, my lord.
My page 37, 35 is my certificate. This number is very same there.
That number is the same reference number. That is the contract number which he has got when he has done the apprenticeship in the refinery.
The post is vacant. I think you can consider. Technically, yes, you may be right, but then this is taking a very hard stand. And you're getting a very good candidate. He has performed well.
That is there, my lord. But the difficulty is that as per the advertisement, once he has uploaded the documents, the correction is not Permissible, my lord.
That is a stand which is taken by the under secretaries in a department. A lawyer should not take that stand. Why don't you get back to IOCL? And ask that
I have had that discussion, my lord, with them.
this is the situation. Unless you're absolutely clear that you don't want to take Mr. God. That is there. Your post is vacant.
Post is vacant.
He has that certificate. Number also he gives. And the one page,
No,
one
that-
blank page, was uploaded. Not that it was nothing. See, he created a problem for himself. He had that, the endorsement was on the back side of the,
No, even the
of one of the
first, even
sheets.
the first page was not uploaded, my lord. That is my instructions. And that is the stand in the affidavit.
No, why can't you get back to your client and ask that in such a situation, but suppose the post would have been filled up, you would not have said anything.
Definitely, my lord.
We would not have said anything. Here also, it is only on your, good sense, if it prevails on you. I think the process would be shortened. Take instructions and then we'll pass orders. Under the cover of our orders, you can do that. But then you have to agree.
I'll get back to your lordship on that.
Take instructions.
If your lordship would kindly specify in the order,
Be good.
I'm obliged.
Take that. In the present appeal, the appellant has questioned the judgment dated 19/9/2025, passed by a learned single judge in WPC number 736 of 2025, whereby the decision of the respondent / Indian Oil Corporation Limited, bracket IOCL, to non-suit the appellant has not been interfered with. The appellant contends that he had applied against an advertisement for recruitment to non-executive posts, including the post of junior engineer assistant for bracket PNU, for which 10 posts were available, and out of which 3 posts were reserved for OBC category candidates. The appellant hails from the OBC category. The appellant had passed the computer test. And the appellant had taken the computer test, but his name never figured in the list of successful candidates. First off, only much later was he informed that the necessary apprentice certificate submitted by him did not have the endorsement from the Boiler Authority of Assam as equivalent to BCC second class. The appellant also came to learn that he had obtained 66 marks out of 100. And if the respondent IOCL would have been careful in scrutinizing his application, he would have been appointed. The place is still vacant. The post is still vacant. The post has still not been filled up.
Because there was an interim order. my lord.
Post was still not filled up for an interim order passed by this court. The main contention of the appellant is that the boiler certificate, that the endorsement from the Boiler Authority of Assam was uploaded, but the same was inscribed on the back side of the paper, which perhaps could not be downloaded. Considering such statement, we asked the learned counsel for the IOCL to produce the copy of the form filled up by the appellant. The photocopy of the form filled up by the appellant online was produced before us for inspection. It appears that the certificate required for making the petitioner eligible could not be downloaded,
No, my lord, my stand is it was not uploaded.
was not uploaded.
Not uploaded.
Stop. The Mr. Gaur, learned advocate for the appellant, submits that the same was done, as there was no reason for him not to do so when he had that certification with him. And the reference number also was intimated by him in the requisite column of the form. We are tentatively of the view that there was some problem in downloading the form filled up by the appellant. Under these circumstances, we seek the specific instruction from the IOC. We seek the specific stand of IOCL, whether the claim of the appellant could be considered, especially in view of the fact that the post still remains unfilled. And the appellant has performed very well in the computer and other tests. What is it? Mr. Deca, learned counsel for IOCL, submits that he shall take clear instructions and shall get back to the spot by the next day, January. Take a practical view of the matter and don't be unnecessarily hidebound and rigid. It never helps if you display a dyed in the wool kind of a approach.
Right.
Now, we don't doubt Mr. Gaur's client for having uploaded that. And many a times it happens that in the communication channel, something happens and things are not downloaded. He has uploaded, he's ready to give his his laptop for necessary verification. Just find out if it could be done. Otherwise, he has a bad case, bad luck. Bad luck for him. Just
Can
find out.
can it be in the month of December, my lord?
Yeah, we can. Why not?
Because the posts are vacant, my lord, lying
All right.
vacant, that is good.
We can keep it next week if you can take it.
Next week may be difficult, my lord. Can we have it sometime in the third week of December, my lord?
Third week of December,
16th, my lord.
16th of December.
I'm available.
Be slightly more practical. Ask your company.
I'll convey, my lord.
We are not forcing it on you.
And
We are not forcing it on you. We are only seeking your consent. We could have ordered. We
Well-
could have said that practical prima facie. Therefore, we have said we are tentatively of the view. There is no reason why he should not upload.
But I have taken specific instructions. It was a mistake
Take
on his.
instruction again
I'll, my lord.
with the mindset of the court.
In
What
fact,
has been communicated.
in fact, my lord, I have asked them that if we can,
And he has the qualification.
he has the qualification.
He performed very well.
Yes.
My lord, I was second in the general, all the
We
categories.
have said so.
Yes, ma'am.
We have said so.
Mm.
Just find out if it will be done.
Item number 3.
Burn. Yes, Mr. Saikia.
Lordship, we have tried our best, but the only difficulty is that they were contractual employees under the state health
Under the society,
society, so not under state. So under the MOU also, we have
under the MOU, you had said that you will take the responsibility of the employees to regularize them.
regularized them, but those
You
are
had said
government
that.
employees, the
Huh?
government contractual employees. We have two categories of. So they are totally under the society, and now this is not the solitary case. In all other hospitals, we have this kind of employees.
No, it was a government society, no. It
It's
was
just
meant, because under the MOU, you had said, and all appointments were made at the behest of the government through the society. And it was a contractual engagement, they are all qualified people. Now, whether Jago and Dharam Singh would come to their aid, that's the question.
They, in my humble submission, no, Lordship. Because we have about 35,000 contractual employees under the government and about 7,000 work charge employees. Those are getting all the benefits from Jagjit Singh. Then our High Court's case also, Ajit Kolita, everybody is getting their service ensured till
But they are out of their job.
they are out of that job. Because they do not
And
come
your
to that
posts are
channel.
filled up.
Here, we have the full, I have the report, we have annexed it. There is no requirement of any additional employee. If we have to give them any job, then we have to create post.
Lordship, Lordship,
Had it been a case of these 7 or 8 persons, we would have immediately agreed. But it will open the floodgate for about 2,000-3,000 people.
Lordship,
All
were employed in Burn Hospital.
Not only here,
No.
all
that-
hospitals.
That will not open floodgate, will make it limited to this only.
In the barn hall, they, what work they are working as ward boy or driver or normal. These are not specialists, Lordship. We have given there in paragraph 7.
Many
we have-
times our hands are bound.
Lordship,
because of the
otherwise,
law.
otherwise we are always, we don't have any difficulty. Had it been a solitary case. For Lakhimpur, identical cases are pending before this honorable court. In fact, every government hospital have this kind of employments.
And they served your society for how long? I mean, not society, they burn hospitals.
Everybody will have individual date of appointments, Lordship.
But long number of years. 10 years.
Not, I don't think too long, Lordship.
Really qualified also, they'll not get any job anywhere. They'll have to be content with private establishment, job,
Lordship.
any private staff.
And that amount also they were not getting from the government. The hospital, the entry, these various fee structures are there for the hospital. From that budget, Lordship, they are getting their salaries and not very high salary also. 2014, they were appointed and 2020, they were discharged. When the hospital was closed and it was amalgamated with the district, this medical college.
But in the memorandum for understanding, there was a promise, no, made by you.
If,
Have we noted that?
page 43,
We have said that.
yes. The state government hereby to take over the rest of maintaining the burn departments at the end of the 11th 5-year plan. That is 31/3/2012.
That's right.
State government shall take over the liability of the staff recruited on contractual basis
Yes,
on
yes.
the end. This contractual basis by the state government, not by the hospital society.
Where do you read it from for the state?
8.2,
8.2 page.
page 43.
Page 43.
Page 43 of the writ appeal, Lordship, 211.
State government commitments. The state government hereby undertakes that it will take over the responsibility for maintaining the burns department after the end of 11th 5-year plan. That's 31/3/2000.
Lordship.
So you continued.
Yeah.
State government shall take over the liability of the staff recruited on contractual basis at the end of 5th year plan. State government shall take steps in advance to engage manpower on permanent basis for running their burns department. So this staff recruited on contractual basis is with respect to the staff recruited under this memorandum. And therefore the society's
No, this is a agreement, MOU, page 41, between the Ministry of Health and Family Welfare, Government of India and the state government for PPPBI. State government has their own chunk of contractual employees,
The state
every
also.
hospital also, under the Health and Family Welfare Department. These the society takes a call when there is a requirement.
They followed their commitment. Hospital was created. It was only for that period. However, this commitment, they say that it is only for staff recruited on contractual basis at the end of the. This commitment is with respect to all, not only to government.
State government, because the hospital society is not directly state government. There is a huge distinction. The constitution of the society as well as the constitution of the State government is totally different.
The officials to be engaged on contract basis. Now, this refers to, now come to 8.3.
State shall create regular posts against the sanctioned contractual position.
Yes. So that.
So
at
that the
end-
end of 11 5-year plan, necessary posts exist for smooth continuation of the burn care services. The officials to be engaged on contract basis initially shall be engaged only if they are found eligible as per the guidelines laid down under. Those contractual employees come under the Health and Family Welfare Department, and they are well protected.
No, one thing more, Mr. AG. Now, we must explore all possibilities so far as they are concerned. Now, pursuant to this memorandum of understanding
Lordship,
between the Ministry of Health and the state of Assam,
Lordship,
the joint director of Dhubri Civil Hospital, he is a government employee.
Lordship,
Joint director of Dhubri Civil Hospital and the deputy commissioner of Dhubri district.
Lordship.
They acted as chairman of the Hospital Management Society of Dhubri Civil Hospital, jointly issued advertisement. So therefore, if you lift the veil, even if it is a society, it is manned by the government officers of the department.
Very few. The majority are from the local area. I can give the complete constitution of the Hospital Management Society, which is prevailing in all across the country, all across the state.
No, but it was pursuant to your understanding. But why can't you do it for them? Because this is your commitment.
This itself, in my humble submission, is not the commitment on behalf of the state government. So far as the employees or the persons who are engaged by the society, the state government has also recruited a lot of contractual employees.
No, during that period, I'm talking about this, the pursuant to the memorandum, when these burn units were being operated. See, the purpose was to operate burn units so that patients with burn injuries could be treated. You did not have necessary infrastructure then. So one hospital, that is Guwahati Medical College and Hospital, and two other peripheral districts.
Nagaon and
Nagaon and Dhubri. Now you say that all these places, they have their own hospitals, even the dispensaries run there were disbanded.
these are district hospital. We have closed it and we have upgraded with a new setup that is a state medical college and hospital. So now we don't have any burn unit there. It is
That's
amalgamated with the surgery department.
Burn unit,
It was a small unit part of the surgery. So now in the medical college of Dhubri, we don't have a separate burn unit. It is a part of the surgery department.
Can you think of even giving them contractual assignments?
That is not required. We have explored that option also.
Look at
Lordship will
this.
kindly
See,
come.
Dharam Singh begins with this caveat, says, when public institutions depend day after day on the same hands to perform permanent tasks,
It is that
equity
is
demands that those tasks are placed on sanctioned posts and those workers are treated with fairness and dignity. This is not rewarding irregular employment. It's about whether years of their contribution.
that is what absolutely. If the state government have engaged them, the issue would not have come. It is because of society. Additionally,
That, Mr. AG, that argument is not appealing to us
but
prima facie, for the reason that this society is a society, I mean, a society was formed for the purposes of running the burn units. But society, basically, the composition of the
these
society.
hospitals are basically run by the government. Everything is given by government. But some small areas, suppose for cleaning the area or for plantation, small time jobs. Like there's a gardener is required in the hospital.
We are not feeling happy to conclude this by dismissing their appeal. The difficulty is this, that the recent trend of judgments are otherwise.
The recent trend, because ultimately, I know the recent trend is very clear. That every judgment of the Supreme Court in recent times is overriding Uma Devi. Now,
Oh, it is. not
now
overriding
Uma Devi was overridden in
clearly
2010.
interpreting Uma Devi. See, in 2010 only, this Kesari's case came.
Kesari's case came and another case of Uttar Pradesh came. Then official liquidator also came. In official liquidator, Lordship would kindly see that how the Supreme Court fail upon their own judges. Why they are not following the full constitution bench judgment. Uma Devi's judgment, how it was diluted in the Uttar Pradesh case by 2 judges. And later on the Supreme Court prevail upon those 2 judges, saying that this should not be done, this judicial discipline must be maintained. And prior to that, state government wanted to regularize everybody. In Assam, Lordship, let us give me
No,
the
that we have seen. I have seen it sitting here for the last 3 months that many such persons have been regularized in different establishment. I can see that.
No,
No,
we
with
have done
respect to-
en masse. In 2004 and 5, we did a recce of the whole state. We have done an audit. And in the first lot, 28,000 MR and 7,000 work charge employees were regularized in 2005. Then we have come to know that there are some leftovers because of the departments were not sending their names on time. So we did the second round, where 13,000 names came to the finance department in 2006. We are about to give it. At that point of time, on 10th of April 2006, Uma Devi came. That stopped our process for regularizing the leftover contractual employees of 13,000. And those cases are still pending. And therefore, in 2013-14, we have taken a decision after following Jagjit Singh's case, Lordship, that we are not going to release them till they attain the age of 60 years. They will get all benefits except the pension. So even at the time of retirement also, they will get some benefits like health and some benefits also we are giving.
Jagjit Singh's case will not apply to them if that logic is pressed. That
No,
their society.
those cases, because we have a very big distinction, if Lordship wants to hear on that point, the employees engaged by the state government as a contractual employee and the persons who were engaged by the society, there's a huge difference, Lordship. So that I would like to argue.
Technically, you may be right. There's no.
We have a soft corner for them also, but it will open a floodgate for more than 3,000 employees. The cases I can cite also where identical cases came from Lakhimpur Civil Hospital. And at both the levels, this honorable, at one case has been remanded back because some points were not argued, so it has gone to the, it has again from the division bench, it went to the learned single judges bench. In that case, we have distinguished between the civil, the state government's contractual employment recruitment as well as vis-a-vis the civil.
Mr. AG, we are not able to make up our mind because of this commitment. Commitment under the MOU. That distinction you have very astutely, I must say, you have very intelligently you have made that distinction. But then it doesn't appeal to our conscience.
Had the state government recruited them as contractual
Then it would
employees,
have been
that
your
things would have been different.
obligation. The question is that your officers, they were chairman of the committee. And it was a governmental,
Government did not pay a single rupee to them till this.
that's all right. It was a concordat. It was a concordat between the Department of Health of the central government and the state government. Look at the parties. Look at the parties between whom the memorandum of understanding was arrived at. That's the reason why we are asking you repeatedly. You have made your point, no doubt. We don't say that your
Then I leave it to
your
this honorable
arguments
body.
your arguments are all justified. But then what to do with this commitment? Can you come out of this?
Let
Only
me-
on the ground that it is a society. This is not a private society, cooperative society. It's a society for the purpose of running the burn units. And you had the commitment, see, these burn units were to be funded. How do you say they were not paid? They were to be funded because it was under a 5-year plan. You said that you will continue with this. Now you continued till the time you had your own infrastructure by way of hospital. Correct. So, but this is just the part of it. They were actually working for you.
They were working for us, but there are different kinds of contractual employees.
We understand. You please explore it again.
Lordship, I'll do that.
And we will limit it to only these persons who are employed in burn hospitals. It will not open a floodgate. We will provide a sluice gate. No, the floodgate doesn't.
Let me only examine.
Yes.
What about the other hospitals without the burn units? They're looking for another.
No, that would
That I
be,
will examine then if there is a distinguishing factor.
you please examine that, but that
Yeah.
would be a different thing altogether. There may not be any.
No,
memorandum of understanding.
in those cases, there may not be identical contracts.
Yes,
MOUs.
yes.
If, let me examine that point. If there is no such thing, then there can be a distinguishing factor. I'll,
Or we are, lingering it for a purpose.
Lordship.
Because we are not.
Then I have also explored, but the department also says if there is a direction, they will definitely accommodate them in some other places, not in Dhubri.
No, we are not judges would unnecessarily, cross that line and direct, which is.
No,
not-
I understand.
Which is.
The
not,
Lordship will also try to explore
which cannot be sustained.
if the other civil hospitals or the government hospitals having the societies, and those societies are not bound by any this
Yes.
kind of MOUs.
That's right. That's right. So this is.
That is the only point. If there is no such things, then there will be no difficulty for us to give the
All right,
concession also.
we adjourn it for Monday, for January.
Let it come in the month of December, Lordship. If it is not inconvenient to the court,
Sorry.
because if it is lingering too long, then the court things will get diluted. So, so
Yes.
3rd or 4th December, Lordship, if it is not inconvenient. I'll come with that instruction only.
Second week of December would.
Lordship, no difficulty. 11, 12, if it is not inconvenient.
Later. Apropos the order dated 15/9/2025. The learned advocate general examined the matter and submitted before us today that the appellants were the contractual employees who were brought in service by the health society and not by the government. In fact, they were not even paid by the government during their entire contractual tenure. To recapitulate the facts arising in this appeal, in the year 2010, a memorandum of understanding was executed between the Ministry of Health and Family Welfare, Government of India, and the Government of Assam for implementation of the National Program for Prevention and Management of Burn Injuries. The objective of this national program was to establish adequate treatment facilities for burn injuries, especially in the district level hospitals and their peripheral health care institutions. To give shape to this program, one medical college and 2 adjacent districts in 3 states were selected on a pilot basis for implementation. In the state of Assam, the burn unit was being run in the Guwahati Medical College Hospital, Whereas in the districts of Nagaon and Dhubri, special burn units were opened in which the appellants were employed on contractual basis by the society. Stop. Over a period of time, the state could make the necessary infrastructure, and two regular hospitals came up at Nagaon and Dhubri. So because of that, the district hospital, which was running as Burn Hospital, was disbanded. It's only under these circumstances that the appellants became jobless, as they were the contractual employees of the society. The state is not willing to take them in, notwithstanding the judgment of the Supreme Court in Dharam Singh and others versus state of UP and others, the citation level. Jaggo versus Union of India, 2024, SCC online, SC 3826. And Shripal and another versus Nagar Nigam Ghaziabad, 2025, SCC online, SC 221. On the ground, notwithstanding the judgment, on the ground that the appellants are not contractual employees of the state, but of the society. The learned AG found out that there are many such contractual employees in different hospitals who have not been regularized. Regularizing the services of the appellants or giving them contractual subsistence or giving them or extending their contractual assignment would only open a floodgate for many such employees who were engaged on ad hoc, temporary, or on contract basis. Contract basis. The memorandum of understanding between the Ministry of Health and Welfare and the state of Assam clearly provided that the burn unit setup would be maintained till the end of the 11th financial year, whereafter the state would undertake the responsibility of accommodating the employees on contract against sanctioned posts to be created in future. Page kitna tha? 41. Page kitna? 41. Improvement. To be created in future. In fact, clause 8 of the memorandum of understanding is being reproduced here for ready reference, page 43 cell. The learned advocate general submits that the commitment made in clause 8.3 of the memorandum of understanding is with respect to only the contractual employees of the state government and not of the society. As we have noted earlier, in the order dated 15/9/2025 referred to above, that pursuant to this memorandum of understanding, the joint director of Dhubri Civil Hospital and the deputy commissioner of Dhubri district actually formed a body under the name and style of Hospital Management Society of Dhubri Civil Hospital. And this society had issued advertisement inviting applications for various contractual posts to run the burn unit at Dhubri Civil Hospital. Similar arrangement was made in Nagaon Hospital. Nagaon burn unit. In that case, the position of the appellants would be akin to contractual employees of the state government. Contractual employees under the state establishment. The learned advocate general has submitted that he shall again explore the possibility of accommodating the appellants. For the reason of their experience and also for a wider understanding of the terms of the memorandum of understanding. Let this matter come up for consideration again. On which date did you say?
11th of December. If it,
11th of December.
Lordship, one thing, Lordship, they have been paid by the government itself, Lordship, on record.
No?
Yes. I'm obliged.
deeply obliged.
For hearing, item 8.
Stop here. It was. Yes.
But very good. So I'm sealing the order dated 28/2018.
Louder, sir, louder. Louder.
Lordship. So first day, my lord, the claim in the writ petition.
Yes.
The writ petitioner, my lord, basically his grievance was that in spite of, my lord, his name being forwarded for the post by the employment exchange, he did not receive the calling letter. That was the, my lord, the grievance. And secondly, to urge Malafide, he has said only, my lord, the calling letters were issued only to the present appellant who were made respondent number 5 and 6. That is the, my lord, two basic, my lord, ground on which the writ petition was filed. Now the affidavit has been filed by the state government. And in the affidavit, it is clearly said that 50 persons were recommended by the district employment exchange. And the calling letter,
All of them received call letters.
all of them have been
The
received.
question is this. It was only from amongst employment exchange sponsored candidates, which is not permissible.
Lordship, my lord. Well,
So
first,
on that ground, the order appealed against has to be sustained.
my lord will consider one way. First of all, grievance as I, my lord, have submitted. This was not the grievance that he did not have the notice of the, my lord, my lord, employment. My lord. In fact, he knows that his name has already been, my lord, sponsored by my lord, the employment exchange.
But he never got, forget about that writ petitioner,
Lordship.
because he stoked it, he flagged it with respect to his case.
Lordship.
But the court found out that this was against the basic tenet of appointment and fairness in appointment.
Lordship.
Article 14 and 16 of the Constitution of India, beginning from Ropaya's case.
Lordship.
And then finally, several cases, though the 11th single judge has relied on one judgment of 2011,
Lordship.
this is now the standard, reasoning.
Lordship.
Employment exchange is one channel,
Right.
but it cannot remain the only channel.
Right.
There has to be total dissemination of the information about the recruitment process.
Right.
So this is what happened. Now, nobody else came forward. He was the one who was sponsored, but he never got a call. So far, so good. The affidavit of the state helps you that he also got a call.
Right.
He chose not to come, and
Right.
now he's
And in fact, my lord,
challenging. No, we are not on that at all. On a wider concept of, the entire recruitment being based on the employment exchange channel, which is not permissible under the law. What do you have to say to this? Can you go against law? We can't.
But that is, my lord, if that be, my lord, so, my lord, in that case, perhaps, my lord, the entire selection process would have been, my lord, vitiated.
But he does it only for this.
Only for this, present appellant, only
Yeah,
two posts
This
in
is
the.
the only ground that can be argued.
Lord.
This is the only ground that can be argued. Yes, state. But nonetheless, we don't find fault with it.
And now,
Others,
my lord,
I don't know if,
now, my lord, in
if some writ petitioner would come up, we will.
2010, my lord, the appointments were made, my lord, and by now more than, my lord, 13 years gone by, my lord, this present appellant have been promoted to other posts also, my lord. So to the higher post.
The law is very clear, Mali versus state of UP, it says that even if there is a long tenure of such employment, but if it is only through the employment exchange, it can be set aside. It's a very harsh order, but that is the law.
That is one, but that is correct, my lord. But here, my lord, looking at the facts and circumstances of the case, my lord, even if it is, my lord, lordship held, my lord, the.
At other places, they are having.
Now, my lord, 15 years almost, my lord, have gone by, my lord. And in the affidavit, if your lordship looks into the, my lord, stand of the, my lord,
Just a minute.
writ petition.
You were respondent number 5 and 6.
Lord.
He will have to be noted. Is here. The writ petitioner has to be here. Mr. This appointment was done when?
2010, my lord, precisely on 21/8/2010.
Have you been thrown out of your job?
No, my lord, there's in stay order, my lord.
There's a
passed by the
stay
court, my lord. Order dated 2012/2022.
Now, presently, you're appearing for the writ petitioner? The respondent.
There are some facts in this matter, my lord. If you'll also report.
No, are you appearing for the writ petition? The
I
respondent.
am appearing for the respondent number 1, and the respondent number 1 says that he did not file the writ petition and he has been impersonated.
He has been?
Impersonated. And that's how your lordship had directed the SP Dhobri to inquire into the matter. And after inquiry, it was,
So you don't want to,
no, I don't want to raise this case, ma'am.
My lord, may look into the order dated
So
9/6/23.
Saikia, you have, what have you done to them? You have actually. Oh, God.
Lordship, may kindly have a look to the order dated 9/6/2023. I did not know he has filed an affidavit, my lord. Then only, my lord, this issue has come. My lord. Otherwise, you have made them.
I didn't see that.
9/6.
Order dated,
23.
order dated
9/6/2023.
9/6/2023.
Lordship.
इसमें तो है ही नहीं है, इतना पुराना होना। 19/9/2003 है, और पीछे जाना। What happened? Unperformed. 9/6/23. What has it? Report क्या? Long years and 8 months. That is, stage again, you are not arranging it. सब इधर उधर हो रहा है, that's not fake, there are. और तुम arrange क्यों हो गया नाइट में आप? चलो ठीक। We have heard Mr. P.J. Saikia, learned senior advocate, assisted by MS M. Nirala for the appellants. Mr. B. Prasad for respond number 1. And Mr. P. Saikia is here. Mr. P. Saikia, government advocate Assam. By the impugned judgment dated 28/2018, 28/2018, a bench of this court, on finding that the appointment of the appellants was only on the basis of that the appointment of the appellants was appointment of the appellants was what have I said? Were made through a process in which only employment exchange sponsored candidates were considered, comma, it was not sustainable, notwithstanding the number of years which had passed by when the matter was brought to the notice of this court. As such, the appointments of the appellants were cancelled, were set aside, and the state respondents were given the liberty to fill up the posts again by calling for advertisement for filling up the said posts by way of newspaper publications, comma, through electronic media and the employment exchange office. The said selection process for filling up of 2 resultant vacant posts of field assistant in Dhubri district was directed to be completed within a period of 6 months from the date of the receipt of the certified copy of the judgment referred to above. It was also clarified that in the event of the writ petitioner who had pointed out that he had not, who had pointed out that though he was also sponsored by the employment exchange, but did not get a call letter, comma, had become overage, the state would consider state would consider relaxing the age requirement as against him at the time of fresh selection to the two vacant posts of field assistants under the crop insurance scheme in the district of Dhubri. It must be noted here that the judgment was put in abeyance by an order of this court, which stay order continues till date. It continues till date. The appointments were conducted in the year 2010. Next paragraph, please. The appointments in question were conducted in the year 2010. The process of appointment was initiated at the behest of the Director of Agriculture, Assam, to fill up 7 posts of field assistant under the crop insurance scheme across various districts, including 2 posts specifically for the Dhubri district. The process of recruitment had the government approval and financial concurrence. However, the names of the candidates to be selected was requisitioned exclusively from the District Employment Exchange as per the district-wise vacancy allocation. For the district of Dhubri, 50 candidates were sponsored by the local employment exchange, who were issued interview call letters. Interviews were held in which the appellants were selected. One of them falls in unreserved category, whereas the other is a person of scheduled caste category. The appellants were thus appointed and they joined duty in August 2010. And as noted above, they have been serving satisfactorily since then. Next. A writ petition by WPC number 8 of 2011 was filed by an unsuccessful candidate from Dhubri, challenging the entire selection process as arbitrary and non-transparent. He has been arraigned as respondent number 1 in the present appeal. Before the writ court, he had alleged that there was no public advertisement. He alleged that no public advertisement He alleged that no public advertisement was issued, and the call letters were only selectively sent. The contention was based on the fact that despite his name having been sponsored by the local employment exchange, he did not receive the call letter for interview. Certain other grounds also were raised, namely that the time when the recruitments were made, the financial concurrence of the scheme had also lapsed. and that one of the appellants was accused in a criminal case. Bracket only. He has since been acquitted. The respondent state before the writ court contended that as per the vacancy district-wise, names were requisitioned from the concerned employment exchange for the district of Dhubri, 50 candidates were sponsored by the employment exchange, all of whom were issued interview letters, but only 31 of them actually appeared for interview. The learned single judge after examining the records of the recruitment found that it was only administratively decided to issue 50 call letters against the 50 sponsored candidates under the Dhubri district, which did not evince that all 50 sponsored candidates were sent the interview letters, comma, the writ petitioner / respondent number 1 being one of them. The learned single judge thus concluded that no individual call letter had been issued to the writ petitioner / respondent number 1, and there was nothing on record to show that all individuals in all sponsored candidates were individually sent the selection, sent the call letter. However, leaving that issue, comma, leaving that issue with the observation that every person, including the writ petitioner, was entitled to be considered for being appointed, the learned single judge, relying on the judgment of the Supreme Court in State of Orissa versus Mamta Mohanty, 2011, 3 SCC 436, set aside the appointment of the appellants as the appointments having been made under a process which was not properly advertised and was based only on the requisition and consequent sponsoring of the names by the concerned employment exchange. So far as the question of law is concerned, comma, it would be necessary here to state that in the past, consideration of employment exchange sponsored candidates for recruitment was found to be a process which would to a large extent avoid the menace of nepotism and corruption in public employment. However, later, the reasoning, however, later a reasoning was adopted that not all eligible candidates for a particular post would be registered with the employment exchange. Would be registered with the employment exchange. The employment exchange. The object of recruitment to any service or post is to secure the most suitable person who answers the demands of the requirements of the job. In the case of public employment, it is necessary to eliminate arbitrariness and favoritism and introduce uniformity of standards and orderliness in the matter of employment. There has to be an element of procedural fairness in recruitment. The earlier view that if employment exchange do not reach everywhere, comma, so would be the situation with other methods of advertising vacancies, was later abandoned. In Excise Superintendent versus KBN Viseshwara Rao, 1996, 6 SCC 216. A three-judge bench of the Supreme Court, while reiterating that requisitioning authority / establishment must send intimation to the employment exchange, and the latter should sponsor the names of the candidates. Observe that to be more fair, comma, in addition to such requisitioning through employment exchange, comma, the appropriate department or undertaking or establishment should call for the names by publication in the newspapers having wider circulation and also display on their office notice boards or announce on radio, comma, television and employment news bulletins, and then consider the cases of all the candidates who have applied. It was held that if this process is adopted, comma, fair play would be subserved. The equality of opportunity in the matter of employment would be available, thus, to all eligible candidates. Next, the same principle was reiterated in Arun Kumar Nayak versus Union of India, 2006, 8 SCC 111. And in State of Bihar versus Upendra Narayan Singh and others. 2009, 5 SCC 65. 65. The law, therefore, as it stands today, is that notwithstanding the existence of employment exchanges, bracket compulsory notification of vacancies act, vacancies के बाद bracket closed. Notwithstanding the existence as on date of the employment exchanges, bracket compulsory notification of vacancies, bracket closed, Act 1959, which cast a duty on the employer in every establishment in public sector in the state or a part thereof to notify every vacancy to the employment exchange before filling up the same, comma, the vacancies have to be advertised and the employment exchange sponsored candidates and the employment exchange notification shall not be the exclusive mode of recruitment. Respective employment exchanges may be intimated about the vacancy position, but it cannot be held to be exclusively. But it cannot be used as an exclusive source for recruitment. What the judgments of the Supreme Court specify is that open advertisement is mandatory in any kind of public employment. In some of the cases, the Supreme Court has gone on to state that if a recruitment has been made only on the basis of only from amongst employment exchange sponsored candidates, even their long service are liable to be struck down. So far, for the policy of recruitment and its execution. But a peculiar situation has arisen in the present case where the writ petitioner / respondent number 1 made an upfront statement before the appellate court, before this court, made an upfront statement before this court that he had never filed any writ petition and that his name was used. Somebody else had impersonated him and had filed a writ petition challenging the appointment process. Mr. B. Prashad, learned advocate for the writ petitioner / respondent number 1 submits that that he doesn't want to contest this case as he was not the writ petitioner. It would only be fair to state here that his statement was not accepted on its face value, and an inquiry was directed by the superintendent of police to find out whether there was an impersonation or there was an impersonation. The report on record indicates that the signature of respondent number 1 obtained during the investigation, obtained during the inquiry, and the signature on the writ petition and wakalatnama are the same, are by the same. So nonetheless, leaving that issue aside, for the present, we have taken into account the clear admission of respondent number 1 that he doesn't want to contest this case as a respondent. We are at a loss to understand why such an exercise was conducted and by whom, if not the respondent number 1, for unsettling the appointments which were made about how many years ago?
Nearly 50,
24 years ago.
15.
Nearly 15 years ago. There is no gainsaying that the appointment of the appellants were only on the basis of the names sponsored by the concerned employment exchange. But considering the long years of service about which no complaint has been made, and there is at present no objection with respect to such appointment, we are not inclined to unsettle their appointments for the present. Unsettle their appointment. Though we approve of the reasoning of the learned single judge and his exposition of the law on the subject, but looking at the entire issue with a pragmatic view and finding that there is no real objection to their appointments, on which they have been continuing till today, on which posts they have been continuing till today, we set aside the judgment of the learned single judge, and we set aside the judgment of the learned single judge and direct that the appointment the appointment of the appellants be held to be valid in the eyes of law. However, we caution that in future, all here, 142 quarter. However, in future, we caution that any appointment exercise, any recruitment exercise ought to be carried out after fully advertising the vacancy position and the eligibility requirements. The appeal. As a listener, reasoning of the learned single judge, we set aside the operative portion of the judgment. We set aside the operative portion. The appeal stands allowed to the extent indicated.
There's some, perhaps, there's some shift in the that ratio that has been laid down.
What?
I have come across one of the judgment of 2020, where the petitioner was
The
appointed.
baseline is that it has to be advertised. How can it be scaled down to any? That's the law. Upen Narayan Singh is the last one which says, though it was the Supreme Court also talked about the spoil system and other things and what is the concept of spoil system, how it all came with whose administration. But then this is the accepted norm. Employment exchanges have lost their relevance.
That's true, my lord, that's true.
But because
But only
the,
thing is
the,
that what I
the
am on,
Parliamentary Act,
challenge has to be made on that count, my lord, that is.
that's a good
Look.
count. It says Mali versus state of UP. I'm forgetting the name. I may have noted it somewhere. Mali
this
versus
is-
state
this
of
is
UP.
one
It
of-
says,
one-
no, see, Mr. Saikia, you are saved only because of
Lordship, my
him.
lordship, that is true.
And therefore, we are not troubling him for having made, a statement which could, bring him within the ambit of the offense of perjury. So we have just said that to be fair, but we are not disturbing your appointment. That's all. You succeed that way. Forget about all. Yes.
Obliged, my lord.
Item 10 to 12.
ठीक है जोल्हा ये तो आदमी
Made prisoners.
we'll come back after 5 minutes if that is
Yes,
not a
yes,
problem.
yes, yes, no problem.
We'll just come back after 5 minutes. We found it difficult to deal with this case. No, the case which we have just disposed of.
Acha.
I was thinking about the case your lordship is likely to take up now.
No. We have not even opened the file. We'll come back at 10 past 12.
Yes, yes.
Yes.
Made prisoner. My lord, by this petition, the petitioners are challenging, my lord, a notification issued by the state government purportedly under, my lord, Article 342A, whereby, my lord, a particular community, they're called Jalha, Jalha. They have been taken out from the.
We were cast in Muslims.
Yes.
They're
these are
Jalha.
Muslims. These are Muslims.
So they have been taken out from more other backward classes
And put in
and
the
they have been
OBC
put in
list.
other backward
And
class.
plus they've been taken out from the list of T tribes.
Because they have been in other backward
Yes.
classes. Because they are in OBC, therefore they have been removed from Tea Garden.
My
and
lord,
ex-Tea Garden.
yes.
Okay.
Now, my lord, our writ petition is.
Now, does it make them any more vulnerable than what they actually are
Yes,
under EBC,
yes.
under OBC?
Yes,
How come?
because, my lord, the benefit of more other backward classes are more.
Okay.
And then OBC. There are more other backward class. It's something like, my lord.
Are you
more-
questioning the competence of the state government to do that?
Yes. Because the, my lord, the lordship knows after the Maharashtra case.
No, I am aware of a case from Bihar.
Yes, that was, my lord, this is case of Bhimrao Ambedkar
Yes,
Bihar
Vichar
Manch.
Manch. Yes.
That was a case dealing with SC, my lord.
Okay, so that's different.
Uh,
But
The
interpretation of
principle,
Article 341.
I have brought the judgment to apply the principles.
Okay.
Hello, just one small information.
Yes.
I am not aware of the recent status of those cases. Possibly when in the West Bengal, more or less a similar issue has come up. And I'm having a copy of the order.
No, what do you want?
My lord,
What do you want actually? This information
just-
you're giving to the bench?
my
for
lord,
what?
the information is that, my lord, possibly so far as the issue as to whether by an executive order, they can change the schedule or not, that issue is pending before the Supreme Court against an order passed by the Calcutta High Court. That is what I am asking. Possibly. I have got two
No, my lord,
orders and
my lord,
it's follow your lordship to consider whether your lordship will wait for that or your lordship will go ahead. Let me just have a
No,
look
when
at-
you use the word possibly, then we ask you to be confirmed about it and then tell us.
My lord, no,
Not possibly.
these, and these are the two orders passed by the Calcutta High Court. That is copy the 8 US signed up. And this has been stayed by the Supreme Court.
Calcutta High Court কি করেছিল?
Calcutta High Court executive order din noa hai. Paragraph 5, my lord, is the argument. He argues that in view of the directions contained in the judgment, it is so and so, the state executive could not have issued the said notifications without including the recommended classes in the Schedule 1 of the 2012 Act upon acceptance of the recommendation of the Commission by the state of West Bengal in discharge of its legislative function. So the argument was only in discharge of legislative function you can do it, not by executive order. Now, that was the interim order here. Para 14 and 15 are relevant. And then in 16, it says, well,
SLP is pending. Why possibly?
SLP, so far as the interim order which I have shown, my lord, that's that SLP is pending.
And that is not a final adjudication, that's an interim order.
And the judgment of the Calcutta High Court based on which all these objections are made.
So better option would be we hear it in January. By that time it will be over.
No, my lord, this is an interim order. There is no final adjudication. Look, the matter is very open and shut case. Number one, It's-
The principle of 341 we know.
yes. No, my lord, our argument is threefold.
Hmm.
First of all, how can you apply this principle based on district? The geographical based classification, this is not permissible.
Now we'll have to see that notification.
Yes.
First, formulate your argument.
Yes.
See the facts later.
Secondly, my lord, as per the, my lord, Article 342A3,
Constitution.
it has to be by law. My lord, lordship knows the while implementing this reservation, a question arose in Indra Sawhney's case, whether reservations can be effected by executive instruction. My lord, noting the distinction between sub-article 3 and sub-article 4 of Article 16, where the Constitution says, my lord, in sub-article 3 it says Parliament may by law, and in sub-article 4 it says state may make provision, meaning thereby by executive instructions you can. Now, if your lordship would kindly come to 342A.
Yes.
Notwithstanding anything contained in clauses 1 and 2, every state or union territory may, by law, prepare and maintain by law.
You're reading 342A.
A sub-article 3, my lord. Notwithstanding anything contained in clauses A and 1 and 2, every state or union territory may by law prepare and maintain for its own purposes a list of socially and educationally backward classes. Entries in this may be different from the central list. So it can be done by the state government because this is a, my lord, amendment by 105 amendment of the Constitution, my lord. This was inserted. You don't find this sub-article 3 in, my lord, Article 341 and 342, which deals with SC and ST. So this inter se assessment is permissible. That is what the seven bench.
342A, please read this.
Yes, my lord. The president may, with respect to any state or union territory, and where it is a state after consulting with the governor thereof, by a public notification, shall specify the socially and educationally backward classes in central list, which shall for the purposes of the central government be deemed to be socially and educationally backward classes in relation to that state or union territory as the case may be. Then B2, Parliament may by law include in or exclude from the central list of socially and educationally backward classes specified in a notification issued under clause 1, any socially and educationally backward class, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. For the purposes of clause 1 and 2, expression settled list means the list of socially and educationally backward classes prepared and maintained by and for the central government. So, my
So
lord,
your argument is that no law was made by these.
it's not an executive fiat, they have done it. Number 2. And number 3, my lord, where are
Now,
the
what was number 1?
number, my lord,
What was your number one argument?
My number one argument was, my lord, this principle has been, picking up process has been applied only respect some districts. Not in all, based on geographical classification.
Now we will see that notification.
Yes.
Okay.
Ah.
So geographical
Classification
classification
Is-
number
is-
two, no law, and the third,
Third is, my lord, whenever, end of the day, when you are giving some preference to some, when you are not giving some preference to some, you are making an, my lord, protective discrimination. And if it is a case of protective discrimination, then the duty cast upon the state to satisfy your lordships. Where are the empirical data? Lordship knows in the seven bench constitution bench judgment recently, the majority has observed one paragraph, which is very relevant in this case. If a lordship should kindly have 2025 1 SC similar, page 1, para 212.
what is that judgment?
My lord, state of Punjab versus that reference, my lord, by the 7 judges constitution bench. Now, my lord, in Jarnail Singh, lordship knows, my lord, even to scheduled caste and scheduled tribe, the creamy layer principle was sought to be applied, which goes against the dicta in, my lord, Indra Soni. Therefore, if your lordship would kindly come to para 212 at page 163. The decision in Indra Soni exempts the
Yeah,
state.
1 minute.
Yes, sorry,
Step three.
page 163. 163. Para 212. 25. The decision in Indra-Soni exempts the state from having to prove that scheduled caste and scheduled tribe are backward for the purpose of securing benefits under Article 15 and 16. The observations do not exempt the state from having to justify the decision of subclassifying within the scheduled caste and scheduled tribe for the purposes of reservation. The basis of subclassification is that few of the caste or groups within the class are more backward. Thus, though the state is not required to collect quantifiable data to prove the backwardness of the entire class of the scheduled caste and scheduled tribe, it is required to collect data to prove inter-se backwardness within the class where it seeks to make a subclassification within the class. So amongst MOBC, when you are trying to make a classification, then this exercise also must be based on some empirical data. In fact, all these principles, they are taken from that judgment of the Krishna in that, my lord, Jagadish Saran's case, where the Supreme Court says, my lord, that it must not only be pleaded, it must be made out, meaning thereby the empirical data must be brought out. Now, this notification has been made applicable to few districts of the state. There are tea gardens almost across the state, my lord. The idea is, my lord, to identify the Muslims and take them out from the MOBC list and from the category of tea garden and ex-tea garden laborers. In fact, my lord, when from Jharkhand, this tea community was brought, a large chunk of, my lord, Muslim also came. There are Christians also. If we go to, my lord, the place like beyond Kokrajhar, these gardens are all manned by, my lord, laborers whose faith is Christianity.
What has the court decided in of course, with respect to SC, Bhimrao Ambedkar Vichar Manch?
There it says you cannot.
So that is very clear. There is no such requirement like 342A3 under 341 and 340.
That's why, my lord, initially I was not inclined to place that judgment. There it has been clearly held, my lord. At para 13, it clearly says, my lord, therefore, if any change is to be made with respect to inclusion or exclusion, not only of any caste, race or tribe, but also a part of a group within any of the caste, race or tribe, the same has to be done by law made by the parliament. there the Honorable Supreme Court was interpreting Article 341. But we are concerned with 342A. Because Milord, similar sub-article 3 do not exist in 341. In fact, Milord, after the Indrasoni judgment, the list was redone also, where our community is included. All India exercise was undertaken. So an executive instruction is not law. Calcutta the interim order.
Let us see the notification dated 1990.
Yes, Milord. Notification is dated,
19/9/2020.
yes, Milord, at page 47. In pursuance of the recommendation made by the Assam Backward Class Commission and in continuation of the government notification dated 27/11/75, the governor of Assam is pleased to enlist Jolha community who are inhabitants of Golaghat, Jorhat, Sibsagar, Biswanath, Tinsukia, Saraidew, Dibrugarh, Lakhimpur, Sonitpur, and Nagaon as separate entity at serial number 32 in the OBC list of Assam and remove them from the list of communities of Tea Garden, ex-Tea Garden tribe of
That's
Assam
true.
under
Now,
M.
where is the requirement that we read that National Backward Commission has to be consulted? Now
That
look at
is,
this.
Milord,
Now, just a minute.
ah,
Now, in pursuance of the recommendation made by Assam Backward Classes Commission.
Yes.
This is commission and in continuance of government notification.
yes,
So these were all, they were brought into MOBC in 1975
ah,
by virtue of a government notification,
yes,
not law.
not yet.
So therefore, this is only an alteration in the government notification from 75.
Yes. No, Milord, but now there is a specific requirement envisaged by the Constitution.
The constitution says that it shall
Ah.
contain for its own purposes.
Ah. No, Milord,
A list of socially and
342A.
educationally backward classes, entries in which may be different from the central.
Ah.
So constitution is clear, the interpretation in different cases.
No, Milord, my humble submission is if we give a literal meaning to Milord, Article 342A
Hmm.
is very clear.
Hmm.
3, notwithstanding anything contained in.
1 and 2. 1
Ah.
and 2 is socially and educationally backward classes.
Uh-huh.
President may with respect
Aha,
so and so.
ah,
Therefore, the president
May-
may with respect to any state or union territory and where the state after consultation with the government thereof by public notification specify
Mm.
the social. So no law is to be made.
ah,
This is a list issued under the advice of consultation with the governor, the and of the state. So
Yes.
that the president issues that notification.
yes,
After consultation with the governor, the socially and educationally backward classes,
Ah.
deemed to be socially and backward classes. So therefore, literally reading it also,
yes,
see, it's very different from 341. Now come to 341.
yes, 341 is different. President may, with respect to any state or union territory and where it is a state, after consultation with the governor by public notification, specify the caste, race, or tribe or parts or a group within the caste, race, or tribe, which shall for the purposes of this constitution be deemed to be scheduled caste in relation to that state. Milord, sub-article 1 is okay, same.
But 2 says that if you make any alteration. you
Parliament
make law.
may by law include or exclude. So and so, so and so. So, Milord, sub-article
That-
1,
That we don't find under 342A3.
no, Milord, sub-article 1 and 2 of all the 3 articles are same.
That's right.
But only
in-
thing is, Milord, in case of
Inclusion.
OBC and MOBC, Milord,
Yes.
the rather socially and educationally backward
That's
classes,
true. So therefore, this has to be state specific.
state
can be
specific,
state
yes,
specific.
yes,
Because other principles also with respect to reservation, they are state specific.
yes,
They may be.
correct. No, my lord, when
So
the,
therefore, why do you read? I mean, of course, the data would be necessary. How do they come to that conclusion? That's different. We are just asking you to explain, where do you read that in 3?
Notwithstanding anything contained in clauses 1
1
and
and
2.
2 is all right. 1 and 2 notification also can be by state.
Every state or union territory may by law
Yeah, by law.
prepare and maintain for its own purposes a list of socially and educationally backward classes. Entries in which they have a different from the
No, that's
central
right.
list.
So if this be the case,
Yes,
then this government, what do you say about government notification dated so and so?
yes.
This had, just a minute, this was in 75. This law, this came in 2021, no?
Yes. 21. 105 amendment. And the central list came in 1993 following Indra Sawhney's judgment.
What happened?
There is a central list, my lord, where we are also included, this community, that came in 1993 following Mandal judgment in Indra Sawhney.
Post that judgment, the main judgment that it has to be done on the basis of data and all that. After that, the central government has not come with any list of.
No, it has come, my lord. That will be next. Kindly come to that, my lord. The page 42. The government of India have had under consideration the judgment of the Supreme Court dated so and so in case of Indra Sawhney and others versus Union of India so and so. Relating to reservation of 27% vacancies in civil posts and services under the government of India in favor of backward classes of OBC. Then please come to paragraph 5, my lord. The National Commission Backward Classes set up under the provisions of the National Commission for Backward Classes Act 1993 in pursuance of direction of the Supreme Court in the aforesaid case shall entertain, examine and recommend upon request for inclusion and complaints of over-inclusion and other inclusion in the list of other backward classes of citizens. The order that a copy of the resolution be communicated to the state government, etc., etc. Then if your lordship would kindly come to page number 44, my lord, serial number 40, Jalha, we are included. Serial number 40. Then, my lord, at page 45 in 2012, Government of India, Ministry of Tribal Affairs, my lord, they issued a central list of OBC for the state of Assam, where our name is indicated as entry 40. Heading is, my lord, central list of OBC for the state of Assam and tea garden laborers, tea garden tribes, ex-tea garden laborer, and E-tribes is as under.
But they have put it in OBC category only, no?
No, my lord.
From MOBC to OBC.
No.
No, here.
In our case, they have been put from MOBC to OBC.
So there, where is the bar?
There is a bar, my lord.
No, OBC, all right. Other backward classes, socially and educationally backward, all come under the main umbrella.
No, my lord, as an MOBC, we get more benefit. As an OBC, we'll get lesser benefit. And my lord, our identity as ex-tea labor has been taken away. Tea garden, that is the most significant thing. Merely because of our religion, how can the Hindus will be, my lord, tea garden laborers and will not be tea garden laborers? On what authority state of Assam does that, my lord? They cannot bring in politics everywhere. Their executive policies are also, my lord, mandated by Nagpur. How can it be permitted? Exactly. Very, very unfortunate, my lord. We have a secular constitution. My lord, the word secular, though it was inscribed by 42nd Amendment, but in 74 itself, my lord, Kesavananda Bharati.
Mr. Chaudhary, you are making a good argument on constitution. Where do you bring in? Where do you bring in the places of importance.
Sometimes when it becomes difficult to resist.
No, my lord, end of the
While
day,
arguing, these statements do come, we don't take note of it, we are
Yes, yes.
treating it lightly.
no, my lord, that's it. My lord. And my lord, I refrain myself.
Lordship, one fact I just wanted to point out, Your Lordship, in my.
But see, you will have ample opportunities of speaking all this elsewhere.
No, my lord, that elsewhere within quote and unquote, it is such a vicious circle, everybody cannot enter now. It has gone to a different level. Even if people desire, people are not going. And the existing set of people, they want that this should continue so that nobody would dare to come here. That's the irony of this country. But, oh,
In fact, Your Lordship, in the item number 11, it is relating to Your Lordship, Borak Valley, Your Lordship. They have filed an affidavit, Your Lordship. There they have categorically stated in para 17, if Your Lordship allows me to read, Your Lordship, it says that with regard to the statements made in paragraph 26 of the present PIL, the opponent begs to state that Jolha community of 3 districts of Borak Valley has not been included as people of Jolha community who belongs to TXT Garden Tribes community are inhabitants of district of Golaghat, Jorhat, Sibsagar, Bishwanath, Tinsukia, Deoghar, Lakhimpur, Sonitpur and some other parts. They have admitted in this affidavit and then they say, Your Lordship, that we don't belong to ST and we are removed, Your Lordship. This is the state's affidavit, Your Lordship, in item number 11. Categorical statement by them, Your Lordship.
anyway, my lord, we are not questioning the wisdom of the state, we are only questioning the decision-making process. এইটো প্ৰায় 18 লাখ মানুহ প্ৰায় আপুনি গোটেই অসমত 8-9 লাখ মানে বৰাক বেলিখিনি থাকক কথা নাই একেবাৰে
Borak. Ne Borak.
জলাটো হেৰি পৰা ঝাৰখণ্ডৰ পৰা আহিছে ওলা কমিটিটো তাতে নাই না
Yes, Mr. Mazumdar.
Yes, madam. With regard to the question of second question, which my learned friend has argued, that only by making a law, this change in the schedule of the list can be made. Here, my lord, I got two full submissions. One, I'm thankful to your lordship. My lordship has pointed out that what the state has now, if at all, tinkered with the list. It is the list which was prepared in 1975 by an executive order.
That is of 75.
75.
Now, after 21, the law has changed.
Law has changed.
Constitution has changed.
My lord, that 75 list is still continuing. Law has changed, but after that, after this, my lord, Supreme Court judgment, there is no fresh list prepared in terms of the judgments of this Supreme Court. Now, my lord, these provisions, the 342A has been, my lord, elaborately discussed and interpreted in that Maratha case, my lord.
That 7 judgment.
Yes, five judges. This is 2023. If your lordship kindly comes to this 2021, I'm sorry, man, 2021 8 SCC, there I'll read a few paragraphs. This has interpreted, my lord, the
এটা তো আমার favorite.
Article 342A.
এইটো খালি নালিলো সেইকাৰণে মই কৰিলো কাৰণে এইটোতো সকলোলে হ'ল আৰ্টিকেল
This is 2021 8 SCC, page 1.
এইটো প্যাৰা 173 পৰা 179 আৰু 181 পৰা
That's it.
দুটা মার্কিং
Page,
It starts from page 1 only.
এইটো মই নানিলো আকৌ সেইকাৰণে।
page.
My lord, it starts from page 1. I am
That's
referring.
great, but which paragraph are you?
My lord, paragraph page 158. My lord, Lordship, I'll first see, my lord, 194.5.1. By introduction of articles, well, I should have read these articles first anyway. By introduction of articles 366, 26C and 342A through the 102, that is 102nd Constitution Amendment, the President alone, to the exclusion of all other authorities, is empowered to identify SCBCs and include them in a list to be published under Article 342A1, which shall be deemed to include SCBCs in relation to each state and union territory for the purposes of the Constitution. The states can, through their existing mechanisms or even statutory commissions, only make suggestions to the President or the Commission under Article 338B for inclusion, exclusion, or modification.
This is with respect to 342A.
Yes, my lord.
Correct.
My
So
lord,
there, naturally, because that has to be made by the president
my
in
lord,
consultation with governor. Governor does not do it himself. For the state would take the inputs from the state backward commission and shall advise. Correct.
my lord, one, if your lordship kindly permits me to read 342A for a moment, lordship, kindly take up the constitutional 342A.
Yes.
There possibly, in my humble submission, subject to your lordship consideration, there is a change in the language of 342A clause 2 and clause 3. Lordship will find in clause 1, it says it is the president who will make the initial list. So far as a modification of the list is concerned, my lord, which is provided in clause 2, it says Parliament may by law include in or exclude from the central list. Now, if your lordship goes to clause 3, it starts with a non-obstante clause and says, notwithstanding anything contained in clause 1 and 2. Now, lordship, instead of saying that state legislature, it says that every state or union territory may by law.
So who makes the law?
My lord.
Mr. Mazumdar, this argument is.
I understand, my lord. I'm trying to.
Who makes the law?
I understand, my lord.
You have other
is a-
arguments. This
my-
argument is not.
My lord, no.
Who makes the law? The
What I'm-
executive doesn't make the law.
My lord, what I'm saying is, my lord, what I'm trying to submit, my lord, is I know where I'm entering, my lord, because lordship has rightly pointed out. If there is a question arises about laying down the law by the state, it is the state legislature and nothing else. But 162 power is also there, where there is no law, your lordship, my lord, possibly the law is where there is no law made by the state by exercising its power under 162.
That's what it's saying, that this could be done. See, this is to be maintained. The union has to maintain a list.
My lord.
The list is prepared by the President of India.
My lord.
That is issued by the President of India. Any inclusion or exclusion
By
would be
Parliament.
by Parliament.
My lord.
And notwithstanding these two, 342A1
Yes,
and 2,
yes.
the state has to maintain by law,
My lord.
socially and educationally backward class.
Yes. Now, my lord, what I'm saying is, my lord, there is already a list prepared in 1975.
So we have understood that argument. We pointed it out, but does it appeal to the reason? No.
My lord. My lord.
Now, this 75, this list was done.
Yes.
Correct. Now we are in 2025, where 2022 amendment applies.
Right.
So now this is an exclusion and inclusion.
Yes. My lord,
So this can be
possibly,
done only by law, no?
possibly, my lord. So far as
So if they argue, if you stretch that argument to the extent that this is nothing called exclusion or inclusion here,
my lord.
this argument would not be tenable.
My lord.
Only for the sake of argument, you can say that this is no exclusion or inclusion. This is just a modification of the earlier executive list of backward.
Yes. my lord.
So every state or union territory may by law prepare or maintain. So they are not preparing, they are not maintaining, they are
Yes.
only making modification. But then can you raise this argument to
But-
any
My
extent?
lord, only possibly I have to argue like that, but because I cannot argue that the state has not made a law, so it is illegal.
No,
My lord, it is not a, my lord, it's not a case of, my lord, preparing or maintaining, as your lordship has statement. It's a case of modification. And affidavit, my lord, we have said why we have modified. And my lord, my submission will be
Argument-
here when,
Argument has to be supported by case law, no?
my lord,
You say that preparation and maintenance of a list by law is
Yes.
different from a list which is already prepared and which is modified. So modification means maintenance. This can now be done only by law. Unless you say otherwise. Same thing continues with respect to 341, 342, central list. All this is first executive
yes, my lord. No, so
and
far,
then changed by virtue of law.
my lord, so far as 341 and 342 are concerned with regard to SCST, the Constitution 1950 order was the original one. And then it says that if there is anything to be done, either inclusion or exclusion, it is only by a law made by Parliament.
So how do you answer this? Forget about other things.
My lord.
Forget about quantifiable data, the necessary data, the groundwork, the commission recommendation, or for whichever reason. And this is with respect to OBC, MOBC.
Yes.
But how can you take away from the tribe status? By what mechanism? By what? How are you authorized? That's the only question.
My only submission will be when the power is given, and when that is why I'm saying I'm trying to make a distinction, my lord, between the expressions used in 2 and 3. While in 2 it says Parliament specifically, 2 it doesn't say specifically legislature, it says state. And state has been given the power.
Yes, you have to abandon this argument. We can't accept it. This
Well,
is
Two,
this is based on a very, very faulty premise. Let's not say it more than what we need to.
Right.
That argument you have to find out other arguments. This is absolutely unacceptable.
Because our present order is not a law, my lord, it's an executive order. That is for,
Now
Yeah.
you have to argue on preparation and maintenance. A separate list,
my lord.
which is to kuch to bahas karenge na.
My lord,
You have
my
to
lord.
argue, you have to defend, no?
My lord, one more argument I have.
This is Mr. Mazumdar, this is abject surrender.
No, I'm not surrendering, my lord. I have got the second, my lord, second leg of argument is, and we have got a state act.
It is always easy and it is always interesting to decide if it is contested. If you don't contest this,
No, my lord, I'm not.
what do we decide? It's one-sided.
My lord, I have got a second leg of argument.
Hmm.
That is based on this Act of 1993 of the state.
Hmm.
This is Assam Backward Classes Commission Act 1993.
Hmm.
This act this act is there in all states, my lord, after that judgment.
That's right.
Ah. This act, if your lordship goes to the, my lord, if your lordship Backward Classes Commission.
Boli na, you tell the argument. We will.
So far as the list has been defined here, I'll read 2 provisions, my lord. List is defined in section 2D. It says list means list prepared by the government from time to time for the purposes of making provision for reservation of appointments or posts in favor of backward classes of citizens, which in the opinion of the government are not adequately represented in the services, and etc., etc. And then section 11, my lord. 11 says the government may at any time shall at the expiration of 10 years from the coming into force of this act and every succeeding period of 10 years thereafter, undertake revision of the list with a view to excluding from such lists those classes who have ceased to be backward classes or for inclusion, including in such list new backward classes.
Secure. What does this argument lead to?
Section 11, man.
Give your list of cases, Mr. Chaudhary, and you also give your list of cases. We will hear on some other day.
My lord.
Lord,
And not only list of cases, don't ask us to retrieve the
what
book.
will do compilation?
Compilation and
Yes.
proper compilation.
Yes, yes.
Give it today, we keep it next week or next to next week, whichever is convenient.
Lordship will give me a couple of days because I'll have to do
Week,
some more.
week includes couple of days. So you can ask couple of weeks.
My, no, I'll furnish.
Today, you started with that, refrain that there is something pending in Supreme. We'll give you time. Build up your argument.
The
You have a
list
weak
of
case.
cases, I'll give it tomorrow, Milord, not.
And you also give, or if tomorrow you give list of cases, we'll fix it sometimes in first week of January.
My lord.
So far as item number 11 is concerned.
We'll hear it together. You also give your.
I will, Your Lordship, but only aspect difference is, Your Lordship, is that they have removed us from the OBC list also, Your Lordship, the Barak Hill people from Jalha community of Barak.
You just give a write-up of 4-5 pages and the compilation, and separately. So that we have a fair background. These cases, as many times you read, it gets obliterated from your memory.
And
There's
most
so-
of when
so
your
much
lordship is
logic,
dealing
theory.
so many matters daily of
So
different.
many logic, so many theories, so many background facts, so many.
Milord,
factors.
this question of bylaw first came up when Milord Article 15 was interpreted by Constitution bench. I think that's a judgment of Balaji's case. I think 55 or 58. Milord, Article 15(4) says that a state may make provision. And Article 15, sub-article 5 says state may by law. That is how, Milord, this, I think Balaji's case.
194 of the Maratha case.
Yes. Yes, Milord.
So, Maratha. You please include in your list the Maratha case, and there is one case which traveled from Bihar, not this Ambedkar,
Acha.
very recent.
Okay.
Judgment delivered by Justice Vinod Chandra, which was upheld in Supreme Court.
Okay. Now his lordship is in Supreme Court, no?
Now he is in Supreme Court, but as a Chief Justice of Patna High Court, he had rendered that judgment. That case also we need.
Milord, actually, we didn't trouble your lordships with the other cases because those were dealing with Milord
No, we
SC
must-
and ST.
That's right. Doesn't matter. No. This Bihar case,
Achha.
it's about OBC.
Okay, then that we'll find out.
Bihar case is OBC. There's lot many things happened. We have heard Mr. Ken Chaudhary, learned senior advocate, and
S. Bothakur.
and Mr. S. Bothakur, learned advocate for the petitioner, and Mr. Dilip Mazumdar, learned additional advocate general, learned additional advocate general for the state. Arguments to continue. What role do you have, Mr. R.K.D. Chaudhary? You're also appearing in this matter.
Basically, it's the act of the state. 340.
All right. But you remain present here on the list on so-and-so day for further argument. First week of January or after Bihu?
Let it be after Bihu, na?
Let it be after Bihu.
Because Milord, January is very dicey, Milord. We
I know,
just
no,
join again, that Bihu comes.
And
what is Bihu?
how many?
Everybody's stomach gets upset because we eat a lot. Then that inertia continues. We take off only after post Bihu, Milord.
Okay. Post Bihu would be sometimes from 19th onwards.
Yes, Milord.
19, 20, 21, kind, whatever is comfortable. So we keep it on Tuesday, huh?
Yes, Milord.
On 20th of January.
Right.
But give that list tomorrow.
Certainly.
Whenever we find time, we will read. And that Bihar case.
Bihar case, I'll find out.
And after any day after 27, I've got some personal work, 26.
So we keep it on 27th,
My lord.
27th of January.
My lord.
Deep level.
All the time. Yes.
Item 19 and 20 for admission.
Lord, before I make my submission, yesterday, lordships, it has fallen from your lordships whether the parties would like to withdraw their respective cases.
So that,
But to that extent, my lord, our plan is agreeable. Just indicate.
No, settlement in what terms?
Settlement in terms of section 321 of CRPC,
That the government has to take a call.
government. Government, not only government, the parties and the government. We saw.
321 parties have no role to play, CRPC.
CRPC can get. Now, eventually, state government through the prosecutor will have to place the matter.
But then the parties will have no say.
Yes.
Dr. Jagannath Mishra versus so-and-so.
Yes.
State of Bihar, the rule is very clear.
CRPC. এটা বোধহয় 319 নাকি? BNSS. The public prosecutor or assistant public prosecutor in charge of any case with the consent of the court at any time before the judgment is pronounced. Here is a case because charge sheet has been filed. Withdraw from prosecution of any person either generally or in respect of any one or more of the offenses for which he is tried and upon such withdrawal. And if it is made before a charge has been framed, the accused shall be discharged in respect of such offense or offenses. If it is made after charge has been framed, or when under this code no charge is required, he shall be acquitted in respect of such offense or offenses. Provided that where such of etc. So basically, my lord, if we agree, then my lord will have to approach the government. Government in turn will have to instruct the public prosecutor. And then the court concerned will have to contact with the consent of the court.
That I don't think they would do.
So it's up to
That possibility is not there because you are being prosecuted for charge of rape.
Not rape.
Also.
Not rape.
Or the misbehavior. It's not 376.
No, 354. No 376.
Okay. POCSO 6.
Because of the age.
Mr. Sharma?
Yes, sir. There are lots of ifs and buts, as we go along, probably someday this will happen, but probably we'll try and finish this off at least here,
Oh. This should have been explored a long time back.
Correct.
Mr. Chaudhary.
Anyway, my lord,
But I'm afraid whether in this 321 would apply. Because this immediately.
no, my lord, even at a stage, post framing of charge, before judgment is delivered.
Not on the stage.
Ah.
I'm on the question of the provisions contained in 320 followed by 321. Non-compounding offenses. I'll have to check up. Long time that I have left criminal side.
Yes, some of are compoundable with the permission of the court.
But then it is not even in that schedule, no. That's a serious offense. It will be governed by the POCSO Act.
320.
And the Delhi High Court, your lordship knows, there are a couple of judgments where 376 has been.
You can't be.
Yes, but those judgments have now been held to be wrong.
No.
That's wrong law.
That cannot.
Amar offense কি আছে? পাসপোর্ট না থাকিব ইয়াতে।
No, let us keep
Yes.
that. Let's have it.
Yes.
That's between you two parties. Forget about states in Japan.
Anyway,
You can settle it amongst yourselves.
Correct.
You can.
yes,
If you don't stoke it any further, don't do anything.
okay.
But then the stage has reached such a brink from where any scaling down does not appear to be possible for very many reasons. For very many reasons.
If lordships then come to the impugned judgment, my lord, at page 603. Yesterday we read para 54 and up to 58, my lord.
Yes.
Now the conclusion is recorded from para 76 onwards
Yes.
at page 603. The impugn order bearing so-and-so dated 24/9/21 passed by the SLSC set aside and quashed. Petitioner herein have been able to substantiate the following criteria laid down in Ramesh Bhai. Petitioners have been able to show and prove that petitioner number 1 and her brother have been under care and custody of the petitioner number 2. And this is neither here nor there. Now, 2 is very important. Petitioners have been able to prove that petitioner number 1 as well as her brother did not get any advantage start in their life, being an offspring of an OBC father and a scheduled tribe mother. The petitioner number 1 as well as her brother, having been raised and nurtured since their age of 6 and 2 respectively in the community of the mother, have automatically suffered the deprivation, indignities, humiliations, and handicaps which the petitioner number 2's community have suffered and is suffering till date. My lord, with utmost respect, with all humility at my command, my lord, the findings in C is absolutely wrong, my lord. This can't be. That is not the law, as I can understand, subject to what the lordships may say. D. Petitioners have been able to prove that community of the petitioner number 2 had accepted the petitioner number 1 and their brother as members of the community of the respondent of petitioner number 2. The community of the petitioner number 2 have also identified the petitioner number 1 as well as brothers as members of the petitioner number 2's missing community. My lord, all that the 2 association members of the Guwahati unit, my lord, said was Lina Dole belongs to missing Miri community. Nothing else. I'll come to that. The aspect as to whether petitioner number 1 as well as her brother have been accepted by other people outside the community of petitioner number 2 as belonging to ST community of the mother is not clear from the records. The reasoning being that the inquiry officer, while submitting vigilance report, did not take into consideration the relevant aspect while purportedly making inquiry with persons of locality wherein petitioner number 1 and their brother have been raised. It is also seen that vigilance report being furnished to the petitioner number 2, she could have provided necessary evidence in respect of proof the said aspect as to whether the people other than the people of the community of the petitioner number 2 have identified the petitioner number 1 and a child as belonging to petitioner number 2's community. The court is therefore of the opinion that the matter requests to be remanded back to SLSC to decide only on the aspect as to whether people outside the community of the petitioner number 2 have also been identified by the petitioner number 1 as well as the brother as belonging to petitioner's community or that of the father's community. This court further grants liberty to SLSC to call for another fresh report on the above aspect which have been directed to be considered. That is whether people outside the community of the petitioner number 2 have also identified petitioner number 1 as well as her brother as belonging to petitioner number 2's community, or that their father's community, upon such report being furnished, and if such report goes against the petitioners could be issued a show cause notice along with the said report. It is further observed and directed that in the circumstances such show cause notice and report is furnished, the petitioner herein would be at liberty to file a reply and also adduce such evidence
Yes.
Yes. My lord, in my humble submission, my lord, the summarization by learned single judge of the judgment in Ramesh Bhai in para 54 is partially correct, partially incorrect. That first requirement, that if somebody stays with their parents, that by itself is also a criteria, that is nowhere spelled out, subject to correction, my lord. The basic criteria is, my lord, whether one has suffered disadvantage start in life, whether have suffered indignities, whether have suffered other disadvantages in life. Additionally, my lord, how the people at large consider him to be, him or her. These are the basic criteria. Now please come to page 603, para 77A. Petitioners have been able to show and prove that petitioner number 1 and her brother have been under care and custody of the petitioner number 2. My lord, there is no dispute about that, but this is neither here nor there. In my humble submission, this is not at all relevant. Merely because somebody is born and brought up, that is not a criteria to identify whether in case of an intercaste marriage, the offshoot would take the caste of the either the mother or the father, as the case may be. Now, regarding the second, petitioners have been able to prove that petitioner number 1 as well as her brother did not get any advantageous start in their life, being an offspring of an OBC father and scheduled tribe mother. My lord, to the best of my knowledge and information, my lord, there is no such pleading in the petition, much less any material placed on record. On the contrary, the inquiry officer's report, which finds reflection in the, my lord, order of the SLEC, clearly says just the opposite. Then on what material learned single judge substituted its finding? It's a different thing that it is not even permissible. It is not permissible in law. So my lord, if finding number B goes, everything goes. Nothing survives here, my lord. Therefore, the learned single judge has committed an error. It's a flawed judgment. Assuming, my lord, the other limb of point number 3 as formulated in para 54 is a relevant consideration. That alone will not make her a scheduled tribe. Other requirements have to be satisfied. So where is the question of remand? In other words, what is the wrong which is committed by the SLEC that the learned single just found it to be wrong? Now I'll place, my lord, I'll place that judgment, I'll place it once again, my lord. Navneet Kaur's case, my lord.
No,
2024.
Let's read that paragraph in Ramesh Bhai Tabhai.
Yes, my lord. Para 55, my lord. Page 111 of the paper book.
The Lordship had a loose judgment where the markings are. There was a loose judgment where Lordship have marked.
Will lose judgments have asked, I mean, all get scattered.
Yes.
My lord, page 111 of the compilation,
54.
54 and 55.
Hmm.
In view of the analysis of the earlier decisions and the discussion made above, the legal proposition that seems to emerge is that in an intercaste marriage or marriage between a tribal and a non-tribal, the determination of caste of the offspring is essentially a question of fact to be decided on the basis of the facts adduced in each case. The determination of a caste of a person born of an intercaste marriage or marriages between the tribal and a non-tribal cannot be determined in complete disregard of the attending facts of the case. In an intercaste marriage or a marriage between a tribal and a non-tribal, there may be presumption that the child has taken the caste of the father. This presumption may be stronger in the case where the intercaste marriage or marriage between the tribal and non-tribal husband belongs to a forward caste. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence, and this is important, to show that she was brought up by the mother who belongs to the scheduled caste and scheduled tribe. By virtue of being son of forward caste father, he did not have any advantage start in our life, but on the contrary suffered deprivation, indignities, humilities, and handicap like any other member of the community to which her mother belonged. Additionally, that he was always treated as a member of the community to which her mother belonged, not only by that community, but by people outside the community.
Now, let us come to the
Order of the SLEC.
SLEC.
Yes, page number 60. I think. It starts at 57, operative portion is at page 59.
Yeah. Page 59.
Yes, my lord. The second subpara. Although so-and-so is the offspring from a marriage between a tribal, the mother, and a non-tribal so-and-so, and she has been brought up by her mother, there is no evidence that so-and-so suffered disabilities, social, economical, and educational cumulatively. Srimati so-and-so is an APS officer belonging to class 1 cadre in the government of Assam. She has provided good educational facilities to her daughter in reputed schools of the state. The statement provided by members of the missing community, Sri Korneswar Dole, President, All Guwahati Missing Kebang, and Ranjit Kumar Dole, which are available on record, merely state that the children of Srimati so-and-so belong to missing community, and said statement do not substantiate anything regarding their tribal custom, way of life, etc. of these children, or that children of Srimati Leena Dole suffered disadvantage or disability due to their mother's ST status. On the contrary, the vigilance report has found that though Srimati Leena Dole belongs to so-and-so community and originally hails from Lakhimpur district, he had only little communication link with the people of her native village. The available evidence suggests that good education and amenities were made available and accessible to Sri Simoti so-and-so, and that the condition that by virtue of being daughter of a forward caste father, she did not have any advantage start in life, but on the contrary suffered the deprivation, indignities, humilities, and handicaps like any other member of the community to which her mother belonged, is not fulfilled in her case. So, my lord, in my humble
True, it is true. I mean, we have seen what Dabhai says, Naika says,
Mm.
but then this is laconic.
Mm.
This assessment by the state legal, state caste scrutiny, it's very laconic. It repeats the phrases.
No, my lord, end of the day, there
Now,
has
you
to be
are-
materials.
We agree to that submission that normally the
Ah.
court should not have entered into it. But once the court has entered into it, why
Yes.
should it not be completed now? Because 45 days. Now, we are inclined to say that the observations made by the single judge with respect to A, B, C may or may not be borne out by the evidence. If the whole thing is being decided afresh, let it be decided afresh. That we can say. We have the jurisdiction and we have the materials to say that.
No, my lord, in an appropriate case, yes. But here the learned single judge has substituted the finding, my lord.
No, that we will say that is to be ignored. That is to be ignored. A fresh assessment. The reason is, I mean, we will tell the reason only in our judgment, provided
Yeah.
you don't know.
So far as delivering order is absolutely lordship's
That's
prerogative.
right.
I'm-
So, but you know, you have seen the practice of this court.
No,
We-
I'll do one more thing, my lord. Let me place one more judgment.
No, that judgment is.
No,
I
no,
mean,
no, there's one more on precisely.
That's all right, Mr. Chaudhary,
Yeah.
try and understand this.
Yes.
Now, this judgment controls the observations of the court also.
Hmm.
The judgment which is under challenge.
No, my lord, had it been a case that the view which has been taken by the single judge is a plausible view, then, my lord, things would have been different. My lord, kindly see, the learned single judge's basic premise or the judgment has been structured on the basis, once a scheduled caste or a scheduled tribe is born and brought up by a scheduled caste or a scheduled tribe mother, the presumption would be he or she has to be treated as a scheduled caste or scheduled tribe as the case. But that is what, with great respect, I'll say, my lord, if your lordship kindly
Yes.
goes to para 55 to 58, that is the premise on which the learned single judge proceeds.
That's an incorrect reading. The standard format is this. Any person born of an intercaste marriage, where the father is not a civil tribe, the normal tendency and the normal acceptance of the theory would be that he or she takes the caste of a father.
Father.
But
That can be,
the court says that it is not correct. It is a
in all
rebuttable-
cases,
It's a rebuttable level.
yes.
So therefore, evidence has to be led, number one, that the child was brought up by the mother of the tribal community. This is one of the major factors to decide to go forward. The child is taken care, the child is taken care. So far, so good. We don't say it is neither here nor there. It is one of the starting point. It is the starting point. Whether she, in this case, she had an advantageous start would depend upon the evidence.
Yes.
And this evidence will not only be the evidence with respect to the mother being an IPS officer or APS officer. This has to come in evidence because notwithstanding the fact, if employment would be the major factor, then perhaps the
No, not employment.
no,
How he or she is being brought up.
brought up is one thing.
No, my lord.
Brought up is the starting point.
My lord, when a
No,
person of that
Well,
class will suffer the
Perhaps,
indignity.
Mr. Chaudhary, you are thinking that I am speaking in an adversarial
No, no,
manner.
no.
We are understanding it this way. Under normal condition, the caste of the father would be taken by the offspring
Hmm.
in case of intercaste,
Intercaste
marriage,
marriage.
especially when the father is forward. And we use the expression, especially when the father is non-tribal.
Hmm.
Forward or backward, we don't know. There is no evidence here. But non-tribal, so Otherwise, Mr. Lahan, that is the title, she or he would take the caste of her father. But then the evidence is rebuttable. Therefore, the starting point is who took care of the
Mother.
children? Mother. So therefore, I say that this is the starting point. So far, so good. The observation, we are talking about para 50, the concluding portion of the judgment in 50, whichever page you said, 60.
77.
The second is whether the child had an advantageous start. For that, the evidence has to be discussed, whether there was an advantageous start. It is not to be presumed merely because the mother who took care was an APS officer that they had an advantageous or they did not have an advantageous. And then if you cross that threshold that he had an advantageous start, whether they were treated as members of the community by the members of the community and outside community. This is the way it, I mean, though there is no statutory rule that only after this, like what you decide when a person is a juvenile or not, there are certain things which fall in line. I mean, matriculation certificate is the first, followed by this in the absence of this. No, it's not something like that. It's not a statutory. But when following the dictates of the judgment of Supreme Court, this is the procedure. Now, first is mother took care, that evidence is there. The second, whether it has she or he had an advantageous start and no deprivation, is to be understood in the context. In that context, the position of the mother would also hold relevance. Therefore, the most important criteria to decide which caste she takes
Is the
is the
Milord?
third one.
Yes. No, my lord. In my humble summary, is the second one which is
No,
most
no, no,
relevant.
it will be a polity reading of number 2. Let's argue it. Since your position as a lawyer for the party, you now forget for the moment and you be the officer of the court and decide that the purpose would be defeated. That is not the intent. If that were the intent, then it is nothing. Then it is very easy. If the mother also has a good social status, nothing, everything ends. That's not the criteria here. That's not the criteria here. Therefore, whether the child had an advantageous start will not only depend on the financial status or commercial or the social status of the mother of tribal community, but other factors as well. But this would be an important factor that she is a police officer, of a higher echelon, and then all good education and everything. So therefore here, the only thing which would be controlling the decision making would be whether they were understood to be members of that community. So it goes one after the other. Additional requirement in NICA makes the job difficult. Otherwise, it would have been very easy. Non-tribal father,
No, my lord.
but care taken by mother. Mother is a tribal and mother is a police officer of good rank and studies in school, good school. So this would have ended. I think there has been some mistake in the summarization by the learned single judge.
No, my lord.
But so far as the third aspect is concerned, that the state scrutiny committee is absent. I mean, they only quote. Quoting a particular paragraph or a requirement is not something which can
No,
be
in
seen.
that case, lordships
In
can.
that case, the
No,
argument-
let my lord, the state produce the records. Lordship will go through the records, find out from the evidence whether the SLUC was right or wrong.
No, but
No, my lord.
that's
End of
right.
the day, the satisfaction was derived from the materials.
But it must be part of the record, no?
No, they'll have to produce.
No, it must be part of the record. They would have.
No, it was produced before the learned single judge, but before lordships, it has not been produced.
We will
No,
have.
lordships will go through the records, kindly see whether on each of the component, whether there were materials to arrive at that
Where-
finding.
Who is in possession of the record? Who appears for the state? Who appears for the state?
Mr. Hall.
Mr. Dhar, so you should have informed him, no?
Record of house.
You are junior to Mr. Dhar.
No, my lord. I'm the state.
Or you are only a government advocate.
My lord.
Can you call for him? In the meantime, we are continuing. Please call.
Record was in.
You are the junior.
Yes, Lordship.
You are the junior in case.
Yes.
Why do you require so much of boarding by the court to come in front? You have the records with you?
Yes, Lordship, but
Official record, official government.
official record is not available with me.
After the case was decided by the learned single judge, you returned the record. Yes, that is what you are required to do.
Especially, my lord, that inquiry report of that, and for that inspector CID.
Petitions are available, but.
Ito na, affidavit na.
Official record not available.
See, I have bifurcated these cases only for the purposes of questioning. To my
It's all-
understanding,
That I followed, my lord.
your,
No, my lord, all that I was trying to, submit for lordship's kind consideration was, my lord. Still I feel, my lord, I'm not making this submission because I'm holding somebody's brief. That's my understanding. Maybe right, maybe wrong, that call lordships will take. According to me, lord, the most important salient feature, otherwise, my lord, when we construe a community as a backward, if we go to that,
That is
then we'll find this number two is the most essential requirement, my lord. That has to be fulfilled first.
that is not a socially acceptable, legally acceptable proposition which you are advancing. The difficulty is this. I give you an example. The example may not be totally apt, but you can draw inferences. Suppose a person of the scheduled caste community, forget about tribe and non-tribe, scheduled caste community gets a job, he gets into the IAS or IPS cadre. His son, therefore, should not get the status of scheduled caste. If what you're saying is correct.
No, my lord.
Because that way he comes from a very, an upwardly mobile family.
No, my lord, that, I think,
Therefore,
that concept.
that is not the logic. If you
No,
see
but
Indra
what
Sawhney
I
number
what I
two, Indra
what I was
Sawhney
trying
two,
to,
this was also discussed.
Hmm.
How to decide the issue of backwardness.
Hmm.
There are many other aspects.
Ah.
So therefore, with NICA, and therefore Justice Aftavalam, who wrote the judgment in NICA, he was very categorical in listing the grounds on which it has to be tested. Good, bad, indifferent, unnecessary burden, but then it is what is there. And it has to be followed unless modified or changed. So this,
No, my lord.
otherwise also socially
supposing,
acceptable.
no, my lord, no, my lord, now lordship, supposing lordship wants to remand it. What about the number two? Finding of the single judge?
No. Oh, this is what I said. No.
Ah.
See, I'm again a tentative view. We might change our
Mhm.
after hearing Mr. Sharma, we might change our tentative view is that we would say if we support the remand, we would say that whether it was appropriate for the single judge to have remanded the matter or not, we are holding our hands for it for the time being. But we will say that the state scrutiny committee shall ignore the observations and summarization.
Then the remand would be whole hog.
Yeah. Unless we find something in the records. Unless we find something in the records. The reason is this: summarization, prima facie.
No, as the judgment
to my-
as the judgment
Just a
stand.
minute, Mr. Chaudhary. Subject to what my brother says, we will have consultation now. We are having it every now and then. Summarization does not appear to be correct to me.
Yes.
Correct. Summarization does not appear to be correct. Because from where number two has been culled out, we don't know. Unless we see the records. The single judge saw the records. Therefore, it would be unfair for us to say that this is incorrect unless we see the records.
Without seeing the record, yes.
But prima facie, it appears that this was culled out from somewhere. I mean, we have to find out. Therefore, we hold back our opinion. And in case we find that this has been done, now 45 days, maybe we'll give another 30 days to complete. Matter would end.
Anyway, my lord, I reserve my right of reply subject to what my learned friend Mr.
Yes.
Sharma said.
Yes.
No, you know.
Okay. So grateful, man.
Mr. Sharma, can this court request you not to repeat the
Not at all.
arguments on question of law?
Not at all.
We have already
Absolutely.
read that. Yes.
Malad, I'll take liberty, Malad, to proceed in this manner, subject to whatever.
Yes, yes,
your
you
lordship
proceed
says.
in your own way.
Malad, my primary concern or my primary endeavor before your lordships would be to show that the order of the SLCC, Malad, SLSC, was
State committee,
state committee,
scrutiny
Malad,
committee.
scrutiny committee,
That's
Malad.
easier to remember.
Scrutiny committee's finding were perverse and not in line with the law laid down, Malads, in Malads Ramesh Bhai.
Okay.
So therefore, the interference by the learned single
Was
judge
correct.
was correct, Malad, and I'll make that good.
All right.
Before I do that, Malad, they go into the perversities and how the single judges dealt with that, Malad. I would request your lordships to take these 2 pages because unless and until I'm able to demonstrate the facts, Malad, I will not be able to demonstrate the perversity, Malad. There was a 2-pager that I handed out, Malad. You have another copy of it?
Yes,
I-
a copy to Mr. Chaudhary. also.
Yes, yes, we had given, but we are giving another copy. Lordship sees the first date there, Madad. The spouse 410 Lordships will mark the date. 4/10/2012. The spouse of Lina Doloy passed away at the time her children were aged approximately 6 years and 2 years. Lordship has seen this particular aspect at different stages, Manoj. Why I am emphasizing this, Manoj, and this is not in dispute. The relevance of this is, there are 3 scenarios coming out of Ramesh Bhai. One, where the father is a general caste, Manoj, and the mother is a scheduled caste. Vis-a-vis a scenario where the mother is a general category and the father is a scheduled caste. There the law is absolutely clear, Manoj, that it will go as per the father. With a rebuttable presumption in case of a mother. But that rebuttable presumption primarily was in a context where both the father and the mother were alive and subsisting, Manoj. Here is a case where the mother from 6 years and 2 years started single-handedly taking care of the child. So, Lordships will see my case, my facts in that light and perspective. Point number 1. Point number 2, Lordships will straight away come to Malaj 15/7/2020
Yes.
and 17/7/2020.
Yes.
This is the stage before I made my application for the caste certificate. Malaj. And my mother made it on my behalf, Malaj. Both our behalf, Malaj. Me, my brother, my mother made it on that behalf. Lordships will see 2 certificates that were given prior to this, Malaj, by people of the community. Lordships will see what evidence was there, Malaj. Page 147 of the paper book in 5 of 2025, Malaj. If your Lordships permit me, I'll just quickly read that, Malaj. 147 to start, Malaj.
Yes.
Manoj, kindly see at the top of the page, the letterhead, Manoj. There is some significance in the letterhead. All Guwahati missing Kabang and the address, Manoj, is Guwahati. So Lordships will bear in mind that there is a missing community in Guwahati also, Manoj. So Lordships will just bear in mind. And there is a complete, Manoj, setup as far as Guwahati, as far as missing community is concerned. The single judge refers to that. Malad, this is to certify that Miss Lina Doloy, daughter of so-and-so, who had 2 children, namely so-and-so and so-and-so, have been single-handedly raised and brought up entirely by her mother with the occasional help from her mother, that is my mother's mother, grandmother, and her siblings, that is my aunts. There has been completely no support from the paternal side whatsoever after the demise of her husband, so-and-so Lahan, on 4th October so-and-so, who belonged to the Ahom community. The upbringing of the 2 child, as mentioned above, were raised, educated, and inculcated into the culture tradition and ethos of the missing community, a scheduled tribe of Assam, of which Miss Leena Doloi is herself. Malat? We, the all Assam missing Kabang, are so and are into our community. So they are accepting both of us because we have already been part of the resource culture, etc., of the missing community. We have been brought up by our mother in that social setup, by our grandmother and our aunts in that setup. All of these people, Malad, undisputedly are part of the missing community. The page after that, Malad, 148. 148 is another affidavit given by another gentleman, Malods, which specified the same thing, exactly broadly the same aspects, Malods, were covered. I'm not reading that for paucity, Malods. He is a member of the community, a very, very well-respected member of the missing community. Now, Malods, kindly see my application for the caste certificate that I made, Malods, at 242. Correct.
Yes.
Right, Malad. This was made on our behalf, Malad, by my mother. Lordship sees this is to the Deputy Commissioner, Kamrup Metro, so and so, Malad. With reference to the above, I would like to inform you that I belong to the ST Miri community, caste certificate enclosed. So there is no dispute, Lordship will take it, that my mother is a Miri, no dispute. My mother still takes the benefit of a...
Miri and missing are same.
Yes, it's the same. Further, I was married to so-and-so and 2 children were born out of the wedlock, so-and-so. Birth certificates are enclosed. However, my husband unfortunately expired. At the time of my husband's death, the daughters were so-and-so. Since the death of my husband, I have been bringing up and looking after the needs and requirement of our children as a single parent with the active support of my maternal family, mother and 3 siblings.
That's all right.
Yes, the same, broadly the same thing. Now kindly see 149, Malods, the certificate. So based on this, Malods, and also a recommendation, Malods, by the All Assam Tribal Sangha, Malods, the certificate is given to me. So, Malaj, may kindly look at, as far as this case is concerned, this case, Malaj, how did it go before the scrutiny committee? It is not a case of a grant of a certificate. It is a case of a cancellation of a certificate already granted, Malaj. So, the test that the scrutiny committee ought to have had, Malaj, ought to have been more onerous, more circumspect, Malaj. And this is exactly what a division bench of this honorable court specifically held, and I'll make good that argument. Now your lordships will see what happens thereafter. A legal notice comes to be issued, Malad, at 381. And this is what lordships will find at volume 2 of the paper book.
Yes.
What I want to highlight, Malads, is what was the objection at the time of this legal notice for cancellation of a certificate.
Notice was sent by the appellant here
Yes,
to the DC Kamrup.
yes, Malads.
Yes.
And on what ground? Kindly see, Malads. What ground? Makes very interesting reading. Under instruction of my client, I'd like to inform you then one Leena Doloi so-and-so against my client's woman self case, etc., being investigated. As such, my client preferred so-and-so on the ground. Malad, may kindly thereafter see straight away the last Malad, couple of pages. (383). In view of the above, a suitable reply, claim so-and-so was processed in your office to evaluate the terms of the law applicable, guidelines, etc., all of that, Malad. Now, on what basis? That the mother is, Malad, affluent, and therefore, Malad, we could not get the benefit of the certificate, Malad. Now, lordships will come to 384. Kindly see the order. Lordships will see, my lord, there is a recital there, my lord. Whereas the issuance of the aforesaid through scheduled caste certificate, Lordship sees that. Under question, through aforesaid legal notice received from Costa Pathak advocate on behalf of the client Gaurav Upadhyay, and question the legality and validity of the certificates, since the father of so-and-so was not belonging to a scheduled tribe community and the mother belongs to a higher strata of the society, and hence that children had not gone through discrimination, depreciation, dignities and humilities, although she belongs to the scheduled tribe community. So it was cancelled primarily on two counts. One, that my father was of the upper stratum.
That was right.
Correct.
Followed that. Cancellation could be only on these grounds. no?
Correct. And secondly, my lords, that my mother has a good position in law.
So that's an important aspect.
Yes, my lord.
There's no difficulty.
But kindly see, that's what not the law is. Well, just let me test that argument, my lords. My learned friend seems to lay down a very dangerous proposition, my lords, that the moment a person is of a higher strata,
No, we have said
or and are children born out of that strata, my lord.
that he didn't say.
Yes,
That he didn't say. He
Right.
immediately withdrew that submission when we
pointed out. Yes, my lord.
pointed that.
But
This
he,
is not the fact.
correct.
No,
So-
to correct my friend, what I was trying to submit in the context of how learned single just perceived the issue.
I
It is in
will-
that
I-
context I
I will come to the learned
He
single
was saying
judgment.
what my learned friend has said.
But that would mean, my lords, the highest constitutional functionaries children, my lord, will not, yes, exactly, my lord. Now, my lords, kindly see 385.
But to understand the social, educational and other economic background, that is one of the factors. That may not be the only factor, that is one of the factors.
Uh,
It
but-
is. Go to any judgment, anywhere. it
Yes,
is.
my lord. Yes, that creamy layer kind of a concept, my lord,
There's no need.
Indra Sani, etc.
Everywhere.
Correct, correct,
There's no difficulty.
correct.
Nothing could be exclusively be held to be the controlling factor.
That's right. You have to look at it in a very comprehensive and overall manner, my lord. I completely agree. That is one factor. But the question is then, my lords, in case, my lord, let's assume a scenario where both the parents, my lords, are scheduled caste, scheduled tribe, my lord.
Then the question would not arise.
Yes, my lord. That's right. So
This
there,
question would not arise.
correct. Therefore, your lordship is right in Justice Aftabalam's opinion.
Therefore,
That additional word becomes very important.
therefore, the judges were not using words unnecessarily.
Correct,
Therefore,
absolutely.
they say that born and brought up by a tribal,
Guy, yes.
number one, maintained and looked after by tribal, did not have an advantageous start. These are
The words,
this
very, very carefully put, my lord. Very carefully.
they're disjunct, compartments.
Correct, absolutely right. Now, my lords, kindly see what happened thereafter, my lords, was that based on this, my lord, the order was passed, my lord, cancelling my certificate. I moved before this honorable court. The court had issued notice. The moment the notice got issued, that order got withdrawn. That withdrawal order, your lordships will see at 386. Lordships will just note the page. There is nothing much in that order, my lord. It's just that the order is withdrawn and the matter is sent to the scrutiny committee. Now, my lords,
And there was no order passed by the court.
there was no order,
Only notice.
the writ petition was declared to be infructuous because of this order, because the order challenged by me was already withdrawn. So there was no cause for me to pursue that petition.
It was only on notice.
Only on notice, the correction was done, my lords, and my lords, the matter proceeded therefore before the scrutiny committee, my lord. At least some time I saved, my lords, like that.
Yes.
Interestingly, my lord, therefore, this is the fact scenario where the whole play of things are, my lords. Now let's come to the law. First, my lord, the law is Kumari Madhuri Patil. What does it say?
Madhuri Patil comes later. Madhuri, just a minute.
I will come because,
Mr. Sharma one.
yes, sir.
Madhuri Patil, he pitches in for the reason of the post-decisional, action against you.
No. I
Madhuri
will,
Patil is this.
I am putting it for
Ma-
something else.
Okay.
To show, my lord, the perversity by the scrutiny committee.
Yes.
My lord, may kindly see Madhuri Patil. A summarization of the process in Justice Ramaswamy's opinion.
Yes. Madhuri Patil, I think he has given it in compilation.
Yes, my lord. I had, my lord, handed over a copy on the last occasion. May I then hand over a copy? Where is it?
Copy is there. Yes.
Oh.
Yes, we have.
Lordship has that. Lordships will come straight away. So Lordships, I mentioned in the fact scenario that now the matter is before the scrutiny committee. What was the scope and in what circumstances and manner was the scrutiny committee to proceed and conduct this entire inquiry, my lord,
Yes.
is the question before us now.
Yes.
And that the best judgment, my lord, and the landmark is Madhuri Patil, my lord. Lordships was sealed straight away. My lord's para 5, I'm skipping, my lords, a couple of things. Para 4.
Yes. Yes.
All the state governments shall constitute a committee of 3 officers, namely 1, an additional or joint secretary, or any officer higher in rank of the deputy so-and-so, so-and-so. Well, this was constituted. There is no difficulty.
No, which paragraph? You are not reading paragraph 4.
Para 13, 4. Para 13, well, the numbering is the same. Actually, it's still 1. There is no Roman numbering. Lordship is over the page. Yes, all this. So the committee was formed, no dispute with that. Now let's come to 5. Each directorate should constitute a vigilance cell constituting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into the social status claims. The inspector would go to, Lordship will underline, the local place of residence and the original place from which the candidate hails and usually resides, or in case of a migration to town or city, the place from which he originally hailed. So, my lords, the underlying word is that he should go and visit. Lordships will underline that. I will lay emphasis in terms of the facts here. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate or the guardian or the parent or guardian, as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parent, guardian, or the candidate in relation to their caste, etc., or such other persons. Lordships will underline such other persons who have knowledge of the social status of the candidate, and then submit a report to the director together with all particulars as envisaged in the pro forma, in particular of the scheduled tribe relating to their particular anthropological and so. Para 6. Now, the report is given, my lords, by the vigilance officer. What is the stage after that? The director concerned, on receipt of the report from the vigilance officer, if he found the claim for the social status to be not genuine or doubtful or suspicious or falsely or wrongly claimed, the director concerned, my lords, should issue a show cause notice, very important, my lords, supplying a copy of the report of the vigilance officer to the candidate by registered post with acknowledgement due or through the head of the educational institute concerned. Lordships underline that, my lord. So the process is, once the report comes, if he feels that there is something, my lords, objectionable or that the doubt as far as the certificate is concerned, a show cause notice giving me opportunity to rebut and reply has to be given to me. Then Lordships will kindly see the last portion of that particular paragraph. After giving such opportunity, either in Lordship has the last sentence of the
we have.
or through counsel, the committee shall make such inquiry as it may deem expedient and consider the claims vis-a-vis the objection raised by the candidate or opponent and pass appropriate orders with brief reasons in support thereof.
Yes.
Lordship observed that the learned single judge called for the records, saw the records. My lords, he has observed in the order that the vigilance officer, my lord, never visited any of the places, my lord. One, in spite of our inquiry report or the vigilance officer giving a report against me, no show cause notice was issued.
No, if that be so.
Yes.
Mr. Sharma.
Yes.
If that be so, then the report should have been rejected outrightly.
Absolutely, but
No. But then the single judge goes about summarizing things.
no.
Reports.
I'll come to that. I'll come to that. And I will take your lordships, my lords, on the issue of remand, madam. I will take that on. No difficulty. And I have instructions also to say that I'll,
Now, the moment you argue this.
yes,
Then Mr. Chaudhary will draw your attention to paragraph 15.
yes.
Read paragraph 15.
I will come to 15 also, madam.
Yes.
15 completely demolishes his first case. Completely demolishes, my lords, the 22 appeal before your lordships. What is his case in that, my lords? The case is that because my mother applied for a caste certificate for me,
We are on a different thing. Paragraph 15 you have not read.
paragraph 14 first, my lord.
No, paragraph 15 first. You.
Very well, my lord, very well. As soon as the finding is recorded by the scrutiny,
Paragraph 15, the question then is.
my lords. Oh, very well, my lord. I'll satisfy that, my lord. And if I'm able to show, my lord, even under 15, what does 15 say? Unless, lordships will mark those words.
No, that's right.
Unless found vitiated by judicial review of
No,
any high court.
Therefore,
I will confine myself to within that window only, my lord.
that's
I will not
that is a
be.
very small window.
I will satisfy that
Mr.
window.
Sharma,
Yes.
just hold on for a minute.
Yes.
That small window would not give the justification to the learned single judge to partly accept the report and partly reject it.
My lord, he has not accepted the report at all. I'll show what he says.
How has he not done that?
My lord,
He says that number 1, number 2 satisfied.
no, my lord.
Number 3,
Based-
it must be done.
Based on what? And my lord, as I said earlier, my lord, on instructions.
Therefore, did the single judge exceed his jurisdiction?
My lord, I will
So
say,
suppose a judge finds that the report has not been arrived at correctly. The vigilance officer did not visit, the director did not ask relevant persons. And if there was any report holding that the certificate is spurious or bad or badly wrongly given, you should have been given a notice. All this was not followed, and therefore the entire report is bad. Then the court would not be presumed to be entering into a field which is prohibited for.
I cannot argue against that principle, my lord, because that is law. That is the law, my lord. I will not even try to do that.
So therefore, I mean.
And therefore, I conceded right in the beginning.
Therefore, the argument was avoided. I jumped to the last paragraph. Again, tentative.
Correct.
That if we allow the remand to take place, which we may not, just a minute.
Lordships will. I have no difficulty. I said so on the first date itself.
But we will definitely not allow that observation.
No problem. But, my lord, the findings of law that the learned single judge lays down, obviously that is binding on the scrutiny.
We will remove that.
No, my lord, that will then be, my lord. I will tell you why. Under the jurisdiction as far as,
Conditional remand we are not doing.
my lord, I'll tell you.
Because you'll be making efforts unnecessarily. But we have law,
Yes,
but I mean, this is not 391 of CRPC.
correct. Absolutely not.
This is no conditional remand.
But difficulty would be, my lords, then
See, this is not we will say that this was not the stage of vulnerability from where the remand has been made. If it is bad on some count, it is bad totally. So therefore, you be rest assured. I mean, be happy with that observation of ours. Don't try to, don't make an effort which would be an uphill task for you to conclude.
correct.
Now, the single judge, even if on the third aspect of the matter, if he finds that this has not been taken care of, he is entering into a field for a different opinion. Now, we would be respecting the order passed by the learned single judge, because normally if it is not perverse in appeal, it should not be disturbed. That's what the law says. Now, we are taking all laws of all branches into consideration.
I see that.
But conditional remand here would make it heavily loaded in your favor and against him. That we will not.
I will, if your lordship
Remand
permits
is
me, my lord.
But we will not make it, loaded in favor of anybody.
Very well, my lord. I see what is falling, but it is going to be my endeavor to show, my lord, that what the learned single judge has done, my lord, is within that window that I have, my lord, and therefore he was well within his powers to do this, my lord, and he has not relied on the report at all, my lord. He has found that there was one small gap which he is wanting to fulfill in view of the constraints of time, and in order to give me complete justice in the matter.
No, then, Mr. Sharma, you are arguing against the judgment.
Well, I'm not arguing against the judgment. Lordship will give me some time, my lord. I will try and satisfy your lordship on 3-4 counts. my lord.
Yes.
Now, lordship will see for a moment, my lord.
But where is the difficulty? Why do you have to do all this exercise? We would be happy in allowing the remand to continue, but without any observation. It'll be a total remand.
I will, very well, my
How
lord.
does it affect you?
My lord, it affects me in the sense that the whole process,
We
I'll
will
have
fix
to
a time
undergo the entire process.
Otherwise also Madhuri Patil says that it has to be done expeditiously. We'll fix a time limit.
Very well, my lord. One, very well. Lordship will then protect me to that extent, and lordship will say,
Protection, what protection?
my lord, in the sense, my lord, that the SLCC will give me, my lord, what had happened, I'll just tell you.
That's right, we have read. I mean, some statement against you, that
Yes.
copy should be given so
Yes.
that you can respond.
Not, that is one. Secondly, my lords, the entire investigation has to be done in terms of Madhuri Patil.
Correct.
There's no two ways about it.
Correct.
And my lords, lordships will also,
If the single judge would have done this and would have said that this is not in terms of Madhuri Patil and therefore I reject it, we would have taken no time in dismissing this appeal straight away. The
I see
difficulty
that.
lies in summarizing, segregating, assessing, supplementing his own view, which he cannot. He cannot sit in appeal. He is not the appellate authority. We are not
I see
appellate
that.
authority.
There is no,
We are
but-
not appellate authorities. It has to be seen from above.
my lords, I'll tell you. I mean, from what I little I have understood, my lords, preparing for this matter, the learned single judge probably was absolutely right in correcting the legal part of it, my lords. The interpretation as far as Ramesh Bhai is concerned, what has been given in this judgment, that interpretation is what I respectfully submit has to be maintained. But if
So that could have been more conveniently done in a less assailable manner
correct,
by just quoting the paragraph 55.
but interpreting it also, my lord. So, lordship, may I suggest? Lordships will, my lord, say that the learned scrutiny committee will proceed and decide this issue, my lord, not taking into consideration the findings or, my lords,
Yeah, that's what I'm saying.
yes,
We are repeating it five
But-
times over.
but the general observations on law would have to
Do
stay.
do you think we will do that? Do we say that
I'm
general
only making-
observations? How can there be a question on observation of law?
Then your lordship.
We will not say a word. See, as we are questioning the judgment of the learned single judge, so such questions would be asked about our judgment. This is not the final.
No, I
court.
see completely what
This
is
not the
falling. my lord.
final court. So with respect to the exposition of law,
So I will
judge-
then
the judge has not gone wrong there. But you know, the stages have been set forth in Madhuri Patil. That was not followed. If that was not followed, everything is contaminated.
I see, man.
And
I see what is falling.
Therefore, 1, 2, 3, 4 categorization is useless.
I see the messaging, my lords. So therefore, I will reserve all my power, my lords, for the scrutiny committee, or maybe in the
Correct.
second round, my lords.
Correct. That
I
is a
will
better,
do.
that is a better way.
Yes, my lord. I'll do that.
Where is Mr. Dhar?
My lord, can I also suggest, may I make a small suggestion, my lord? Since I'm conceding on everything, my lord, in
No,
that sense.
we are not asking you to concede.
My lord, so let it be a consent order. I'll tell you why.
No.
because-
No. After hearing, this is not,
Very
Mr. Sharma, we have not asked you to concede.
correct. Correct.
We are not stopping anybody from arguing.
Correct, of course, but I do
We
not
are-
want to waste judicial
It is-
time, my lord.
it is a- time
Once I have
is-
understood what is there in your
time
lordship's
is
mind. my lord.
something- Time is meant for you.
No, my lord, the
This is-
judicial
this-
time is more
No,
important.
this
my
is
lord.
your time. Our time is, I mean, this consumption of time is for a purpose. Now, it is not something, we will not pass orders on our whims. Now, this is how we perceive. Madhuri Patil not followed. What is the fallout? The report is bad. If the report is bad, where is the question of, assessing the report again?
One,
That is what, that's one,
Two.
only.
two, Manoj, there are cases, several cases, Manoj, where the courts have, including a division bench of this court, where the scrutiny committee's report was upheld by the Honorable High Court, Manoj, division bench, where the Supreme Court then goes ahead and says, yes, please grant the certificate, not under 145, Manoj, even otherwise. There is Bombay High Court which has done so, Manoj.
No, but that is.
There are several courts that have done.
That stays, for that, we would be approached much later. Question is that the scrutiny committee says that no. They don't require a certificate of, they don't require a caste certificate. They don't take the caste of the mother. In that case, you challenge that report, number one. If they say that yes, that the earlier report was wrong, we find that the status of this person is of a civil tribe. Then the fallout would be that based on that report, the Kamrup DC will give you a certificate.
Yes.
This will be questioned by him. In either case, it will be questioned by him. Therefore, we are justifying the remand, but with our own logic.
Very well, Manoj.
Let's look at this. Now, when in disciplinary proceedings, when the matters are remanded, suppose the disciplinary authority passes a punishment and the matter comes to High Court. The High Court says remand. The courts have said, even in Karnataka, that remand, wholesale remand, there has to be reason. Why should there be a remand? And remand also should be from the stage of vulnerability. When it is noticed.
Not
as a rule. We are applying the same principle here.
Very well.
And otherwise, the principle of remand, that if the remand is conditional, then
Has to be open remand, Manoj. Open. I have understood.
unless we pinpoint. No, if the court has gone through Madhuri and on that basis, the evidence has been sifted. One, we will hold that such exercise was unnecessary. Number two, if that exercise was undertaken within that small aperture, then perhaps it had to be unconditional.
I'll leave it to your lordship, but only on the principles of natural justice, because the learned single judge
We will say that
on the second part.
No, we will say, we will put every observation under eclipse.
Right. And lordships will keep the entirety of that open without saying that, any observation, all my.
Saying that the scrutiny committee shall observe the procedure for coming to a conclusion.
Yes, ma'am. That protects me, ma'am. That protects me.
It has not to be loaded in favor of anybody or against anybody. This remand is very, very loaded. Right or wrong, we are not the final arbiters. And therefore, these restrictions have been put on the High Court. Article 226, we can traverse in any field, agree.
Correct.
But then these are self-imposed limitations.
But probably the learned single judge was swayed by the facts and the clear perversity, Manoj.
That's. Only everything.
Yes,
Yes.
I'll take.
That is as far as the 5 of 25 is concerned. Since I am in Madhuri Patil, Manoj, just one paragraph that I wanted to show to your lordship,
Yes.
Manoj. That will take care of the other appeal, Manoj. That's why.
No,
Lordships,
the other appeal is against what?
I'll tell you, Manoj. Lordships will just see for a moment the other appeal, Manoj. Para 13, 13. Para 13, sub para 13.
13, yes.
Sorry, 13, 14. I'm so
Yeah.
sorry.
In case the certificate claim.
Correct.
Hmm.
In case the certificate obtained or the social status claimed is found to be false, Let's underline the words, it's found to be false.
Hmm.
The parent guardian, the candidate should be prosecuted for making false claim.
Hmm.
My learned friend's second, the other appeal before your lordship
This
is,
will not apply. He
No, no.
cannot make use of that.
he's,
Let Mr.
he's saying, he's
Mr.
based,
Sharma, please.
yes.
Now, this, I mean, try and understand this. This is with respect to admission on the basis of a certificate which was
Correct.
false.
Correct.
Now, this situation cannot be here.
Yes, well, I'm so
You-
grateful.
You on face of your, in face of your background, in face of your parentage, in face of your, your mother being from tribal community, you claim a certificate.
Absolutely. I'm so,
When you're claiming a certificate.
that is my
there
case,
is no-
my lord.
So therefore, that, we have understood that.
Correct.
This he cannot.
That's fine. I'm so grateful.
This he cannot.
That's all, my lord.
Because it is a matter of interpretation,
Absolutely.
it's a matter of inference, it's
Absolutely.
a matter of a statutory body deciding
I'm so,
whether you should get or not get.
that is what,
Madhuri Patil prosecution, that appeal means nothing.
correct. I'm so grateful. my lord. That is his second appeal.
My lord, I never praised this appeal, my lord. Let us be very clear.
Yes, yes.
No, my lord, but nevertheless,
Uh.
I'll draw your lordship's attention to this. I'll just take 15-minute time of
Right.
yours, my lord.
Mm.
Let us see, my lord. Now I'll be arguing on malice in law.
Okay.
Kindly see the conduct of the parties, my lord. Please come to page 143 of this 388.
My lord, if my learned friend wants to argue, then I'll address a full-fledged argument, my lord. He's getting into, once I have said so, my lord, then it is unfair on his part to go into all of these kind of things. my lord.
Look here. Like,
Why are you so afraid?
No, I am not afraid,
Let
but
me-
I did not proceed, my lord,
Let me,
only on the condition that I wanted to save time.
let me tell both of you. Because of this stand taken before the court of law, you have reached a stage from where there is no comeback.
Correct, very well, my lord.
And it is not to the advantage of both of you.
Yes.
I see that, my lord. I see that. But, my
Yes.
lord, the conduct, my lord,
Why malice in law?
Oh, no,
yes,
I'll
my
come.
lord, and secondly,
no.
my lord, who is saying malice in law, my lord? A person who has molested me, my lord? Malice in law? I'm surprised the conduct, my lord.
My lord,
He's an
even-
IPS
even
officer
hardened
being in
criminal has
duty,
a
my lord.
protection of law.
Just a minute,
I don't understand.
just a minute. We are not dealing with a criminal case.
Yes.
Yes, absolutely, but
So this is purely an issue with respect to grant of status, caste status,
Yes.
tribal status.
correct.
Yes.
So let's keep all such background facts
No,
at
no,
bay.
just one paragraph, my lord.
I agree.
One paragraph. सर्च की हिंदी ठीक है, सर्च करवा होता है.
Mr. Chaudhary, if you raise that argument, perhaps you would only increase the hostility.
Let us see, my lord. We'll face
Because-
the reality.
because you-
My learned friend is afraid of facing reality.
No, no,
That's
no,
why,
no.
my lord, he stood up.
No, no.
No, not at
Mr.
all.
Yes, you are. That's why you are doing that.
Mr. Chaudhary, you would be in a more disadvantageous position.
I'm not on that.
Not
All
with-
that I'm trying
not
to
with
show is, my lord,
Just-
how from the very
Can
beginning.
can you just hear us for 2 minutes? We will give you, I mean, a lawyer can't be stopped, a lawyer can't be gagged. Just here for 2 minutes.
Yes.
Why I'm asking you not to proceed further is for the reason we have told you our mind, though tentative.
No, my lord. What I, no.
Just a
Lordship-
minute, एक मिनट
Okay,
सुनिए ना।
okay, okay.
1 minute सुनिए। What we are saying is that, see, this certificate, whether certificate is granted or not granted, in any case, that is not going to adversely affect you because POCSO Act is more onerous, more difficult, more hostile
Then
to
SC/ST.
use than SC/ST. Nothing. SC/ST, even the provision of bail has been relaxed.
Anyway, my lord.
So therefore,
Anyway,
your
my lord,
effort-
I will
should be that the matter should not, the hostility should not reach a point where you can't have even a possibility of a comeback.
no, my lord.
Why?
My learned friend has read out a list of date. I'm also reading on the list of date. Where from, my lord, I'll try to show the malice in law.
Very well, my lord.
Please come.
Then your
If,
lordship will,
if there is anything against
no,
you,
even otherwise, my lord, then I will take my half an hour or 40 minutes, my lord, to address on, my lord, 3 aspects. One, Ayub Khan series of judgment,
what?
my lord, to demonstrate that he has no right in law as far as proceeding under the scrutiny committee or a caste certificate is concerned. Point 1. Point 2, I will also demonstrate his conduct, my lord, and the manner in which the committee has
Anyway,
proceeded,
first hearing,
which has like
It is my
which
detail, let me start.
which the single judge has said
All
has
right,
happened
we
in a
will-
very hush-hush manner.
We will give you time.
Very well.
We'll give, yes.
Milord will kindly come to page 143 of the other appeal, Milord. How it all happened. I'll just read one paragraph. Kindly permit
Is
me.
it necessary?
Yes,
Is
Milord.
it necessary?
Okay, 143 I'm not reading, but the other, anyway, my lord, I have taken your lordship's words, I'm not reading it, but this is very important. And your lordship will kindly take note of that, my lord. Page 143 of the other appeal. One page, one paragraph. Now, my lord, why the necessity of this certificate error?
We understand.
No. That my learned friend is not placed. My lord will kindly come to page 351. My lord, when SC/ST Act was added, her mother was the superintendent of police, petitioner number 2 was the superintendent of police of CID.
Yes.
At her instance, my lord, this was done.
Is it so difficult to decipher?
No, my lord. Why this certificate was required? Kindly see, there's an order, court's order. I'm referring to only court's order at page 351. Attending facts at para page 354, my lord, for a moment.
Yes.
Please come to paragraph 3.
Yes. For you?
Page 354, para 3.
Yeah.
I hereby direct. Page 354.
Yes.
I hereby direct the investigating officer to conduct investigation as to whether victim belongs to SC/ST category and therefore whether penal provisions of ST/ST Act can be attracted. For the said purpose, birth certificate of the victim, school certificate appended with the additional affidavit and other related documents be referred to. The conclusion does not be brought to the notice of the court along with the supporting documents. Then, my lord, after this order, an affidavit was filed by Assam government, my lord, at page 360.
Now, this is a direction passed by a
My lord, in my petition, my lord, when I challenge,
single judge in criminal petition.
yes. Now, my lord, pursuant to that, investigation was conducted and at page number 368, please come to page 368.
The difficulty is that this order is not sustainable.
It's my lord.
The criminal investigation department or the investigation department could not have
no.
done this.
No, what I'm saying is,
This
kindly
direction
see
is
the, no,
assailable.
kindly see the sequence of events, my lord.
That's all right.
Yes, page 368, one small paragraph.
For what purpose is it?
No,
sir?
I'm trying to show why the certificate was required, my lord.
That we understand.
Why it arose, necessity arose. It's a different thing, my lord. Otherwise, she can apply. I'm not on that. Para 4. However, in the absence of caste certificate in the name of victim, the materials collected so far by the investigating officer, as already mentioned in the preceding paragraph, do not support SC/ST status claim of the victim, although SC/ST status of the victim could not be conclusively established at this stage of the investigation. Now, there was a direction by this honorable court. Please find out. Then there was no certificate. That is how, my lord,
That's
at page number 371,
all right.
this certificate was issued.
Also, this is a highly assailable order. Highly assailable order. This investigation could not have been directed because police is least competent to decide this.
No, I'm not on that. Because
Reason.
you have invoked SC/ST Act,
We have-
therefore court wanted to know
This-
whether the victim is ST.
This is neither here nor there.
Whatever I'm saying, my lord. Now this prompted them to apply and they got it. Now it was cancelled. Kindly see that only for that purpose.
That is the matter.
And my lord, a challenge, my lord, against
No,
the,
if this kind of petition, if it comes before me, I would say that
Yes.
let the investigation
Order
be
to
carried
Supreme
out. We
Court.
will see it after the report.
now my lord, against the order of our High Court, my lord, they preferred an SLP. My SLP order is at page number 356. And please come to page 358.
356.
Yes. And please come to page 358. Para 6, we dispose of the present proceeding with the clarification that directions contained in para 3 of the order of the High Court shall not constrict the duty of the investigating officer
Therefore,
to
prima
investigate
facie-
into all aspects of the complaint,
Therefore, prima
nor do they
facie-
confine the investigation to
prima facie
document.
was passed by the single judge, even though the single judge was Chief Justice, that did not find a favor.
Anyway, my lord, end of the day, my lord, because, my lord, they were not in possession of a ST certificate.
Correct,
Now they did it.
correct.
Now, my lord, one more document. Please come to page 144. They're talking of tribal culture being born and brought up. Please come to page 144, my lord.
How will you?
No, my
how
lord,
will-
kindly see. This
how
is
will
very
you settle
interesting.
The matter, mister.
Yes, yes.
How are you going to?
No,
settle?
my lord, kindly page 144. They're talking of ST status and all. Let us see, my lord.
So
Page
now-
one, no,
now
no,
when
this is
the
very
matter is-
relevant. Attending facts and
So
circumstances,
why
kindly
can't you-
see.
Why can't you reserve this energy for
No,
caste
now,
scrutiny
just,
committee?
this is my last document, my lord. Para 2, that I have 2 children out of my wedlock with my late husband Nilutpal Lahan, the elder being a daughter, Miss Divya Apun Lahan, who is aged 9 years, and son master so-and-so, who is approximately 5 years. Now kindly see next page. That due to some personal reasons, I wish to change the names of my above mentioned 2 children to so-and-so from Miss Apun Lahan. My lord, that's a missing name that they have, my lord, deleted, removed. And Master A. Lion from Master Leander Ayang Lahan, and hence my children shall now be known and referred to call as so-and-so, so-and-so, so-and-so. So that missing identity was removed.
No. Mister, it only says, it only gives the first letter. Now the name
My
is.
lord,
the
this
name is
this
Divyana
word
Apun Lahan.
Apun.
It is Divyana A.
No,
Lahan.
my lord, no, my lord.
A
And
stands
we
for-
see para 3,
On the
third line.
contrary, my lord, I did it for my benefit. I entered into the community by the change of the name. This exactly demonstrates that. There is a subsequent letter which clearly shows the meaning of these two. My lord, let my learned friend finish our show. I
No,
didn't
no,
want
my
to waste the court's time.
No, my lord, why, no, Lord, in this, now I'll come to it, my lord. That due to some personal reason, anyway, my lord, this is the change aspect. Now kindly come to the page. Oh, please come to 148, my lord. This is my last document. This is Ranjit Kumar Dole's certificate, which was relied upon by the scrutiny committee. Second para, third para. Miss Lina Dole has, as mentioned above, raised the educated and inculcated into her 2 children the culture, tradition, ethos of the missing community, a scheduled tribe of Assam, to which she herself belongs. It may also be noted that both the children have words Apun and Ayang, which was removed. No, my lord, this is a very significant thing in this case. Without respect, my lord. Because why he identified them or recognized him as a missing? Because of the use of the word Apun and Ayang. And they have removed that. I leave it to lordships to take a call on this. I just wanted to show this. So therefore, my submission is, my lord.
I will record your submission, but
Yes.
will not enter into this.
No, my lord, my humble submission is a person who is claiming they were relying on 2 certificate of their community, who identifies them with the community because of the use of the 2 names, and they remove those 2 names in October 15, and the certificate is given in 2020. Fairly similar.
Yes.
The certificate was given, he was identified as a person belonging to that community because he is using the name Apun to his name, whereas that was removed in 2015. So therefore, my lord, it's a very, very relevant aspect.
Lahan is a.
No, Lahan is the
Ahom type.
surname of Ahom. Lahan is the surname of Ahom. Lahan is never identified with any Milord missing or a Miri.
No, cannot.
Yes. So therefore, these are the facts, Milord. And as I have already submitted, Milord, the learned single judge has exceeded the jurisdiction in substituting the findings, which is not the, scope of 226, Milord. And therefore, lordship will take an appropriate view in the matter.
All right. For record, we don't want it. Mr. Dhar did not appear.
Malad, to his credit, Malad, he had indicated yesterday, Malad, that he'll be not be available in the second half.
Okay, so we are. All right, arguments heard.
Malad, my point on Ayub Khan, Malad, remains, but I'll let it be, Malad, let it pass, Malad, very well. Malad.
Ayub Khan, we will record.
Malad, that's a clear in case of a specific caste certificate, a stranger to that, because
They will give
Yes.
Ayub.
one, well, it's in my compilation. It's in their compilation also it is there, madam. It is serial number 8.
Yes. 2029S. ini आगे कोई केटिया पा गया तुम्हारा नाम है ना कि तो नहीं नाम था काबिल सर्टिफिकेट भी था
All right, we will see.
Yes.
Are you aware of?
Yes. Malad,
Lord, there is one more
Malad,
judgment
what
of
has
this-
happened, Malad? What has happened in this entirety of the case, Malad? The entire, and this is exactly what the single judge also observes, Malad, that the entire scrutiny committee has been hijacked by a complete stranger, and the entire proceedings, Malad, were directed
This shall not happen again.
very well. Lordships will ensure that that is all that I want, Malad.
My lord, on this
I won't
point,
say a
I'm
word
giving-
Don't ask us to monitor that.
No.
I'm giving one citation on this point,
Yes,
on the Ayub Khan's thing, my lord.
yes, give.
To 2029 SCC 356, para 100 to 103. The scope of, my lord, when can a mandamus be issued?
There are many.
Yeah, there are
When, no, my
200
lord,
judges.
this is a latest judgment, my lord. 2029 SCC 356.
We are, for the present, we are not issuing any mandamus.
No,
We are
since my
exercising-
learned friend
we
has
are
said, that's why I
exercising
brought it.
We are exercising.
Because he is relying on Ayub Khan.
No, Ayub Khan is all right for a different purpose. We are exercising the powers of certiorari and dealing with these single judges.
Correct.
Yes.
That's all.
No mandamus.
No mandamus. In fact, my lord, that,
Mandamus would be interference
no, my lord,
unnecessary.
that, in fact, that petition, appeal you have not even pressed.
We will say that. You have not pressed this. We have heard Mr. K. Chaudhary, learned senior advocate for the appellants. For senior advocate and Mr.
KP Path.
You were always prompting him, so your name also should be there. Assisted by Mr. KP Pathak, advocate for the appellant, and Mr. PP Sharma, assisted by, who is your assistant?
Malad, Hardik Jain and Malad Joyraj.
Give your appearance, please. I can't read this month, but put you. Arguments heard, judgment reserved.
Lordships will direct the scrutiny committee to complete it within a particular time frame, Malad.
They have said so.
Yes, yes. But I just wanted to, Malad, hear it again from you, because that's the only anxiety, nothing else, Malad. So much time. My difficulty is, Malad, today, it's my time, Malad, to get admission in
An
colleges.
advisory from the bench.
Yes, yes.
This is over.
I have already told my clients that
Advisory
yesterday
from the
itself.
bench, better for both of you.
Yes, yes.
Fighting here in
That has
court
already-
is not going to help you.
Yes, I have communicated that.
And Mr. Ken Chaudhary, more so for your client.
Grateful, man. I'm so grateful.
Deep lord.
It's been a pleasure.
तब एक जगह ठीक से करके हमारे पास तो खाली यस नो टोट नहीं है सही है सही है। और बचा है
2 है daily list for hearing item 13.
Lordship, in this matter, Mr. D. Nath is appearing, Lordship.
Where is Mr. D. Nath?
Lordship, he is led by the learned Advocate General
Please.
Assam, Lordship. There is some difficulty on their
That's
behalf,
all right, but let me tell you, so that you
Lordship.
can tell Mr. Nath.
Lordship,
Now, the person concerned, the respondent here,
Lordship,
may be an officer facing grave charges.
Lordship.
But the difficulty is that Ajay Kumar Chaudhary versus Union of India, on which this judgment is based, is the seminal judgment. Every judgment follows this.
Lordship.
Therefore, you don't have a case, no matter how much we may, I mean, this could have been avoided, but then it was your fault.
Lordship.
Post the expiry date, you restore the suspension. Now, what is the stage of departmental proceeding?
That is likely to be completed shortly.
So don't worry. Why do you do this? Ask Mr. Nath to be here tomorrow.
Tomorrow, there is some problem. Let it be next week.
You
Lordship.
get ready. What is your name?
M. Devi, Lordship.
M?
M. Devi, Lordship.
M. Devi.
MDB.
M. Devi.
Lordship, the
M. S.
learned
Devi,
adv-
why can't you argue? You are so aware of the law.
Lordship, the learned Advocate General is appearing in this matter, Lordship.
Mr. Advocate General.
Lordship, Lordship.
21.
Let it come in the next week, Lordship, any day.
They have completed the departmental. Punish him. Or don't acquit him, whichever way. You have already posted him in a non-sensitive post.
They have not, my lord. The order has not been,
Or you have not complied with the order.
no, my lord.
We are dismissing it.
My
You
lord,
face the contempt.
The IA was filed in the month of November last year.
You face the contempt, we are dismissing this.
Lordship, let it be next week, Lordship.
My lord, Monday, if I may implore, my lord.
As prayed for. But see, at many a times you have to accept the verdicts of the court with a pinch of salt because
Lordship, I
we
do
are,
understand.
we don't go by what you say or what he says. We go by the law. I mean, as far as we understand law. So the law says that it cannot be done. It cannot be done. No matter how grave the offense. Suppose there is a very serious criminal charge. But if there is no evidence, what can be done? He has to be acquitted. Likewise, if you don't follow the rules of the department domestic proceeding, now what will happen? The court has not said something new of his own. The court is not treading on a soft approach.
My lord, page 61, my lord, it's their own stipulation.
Despite your time, taking time here, you can always be held up in contempt. At least you will have some, thing to argue before the contempt court that well, we were pursuing the appeal, and now it has been dismissed, we are posting it. Complete your departmental proceeding within 2 months. That is the best answer. As prayed for on behalf of the appellant. With objection from the respondent,
My lord.
the matter is adjourned to next week. Laga dijiye palak.
Monday,
Monday, I'm grateful, my lord. I'm grateful.
Obliged, Lord.
24/11. Item 14,
Lordship, a small accommodation today.
Small.
So,
How small? How small? January.
they have already agreed to the small accommodation which I have.
I agreed, my lord. The
proposed.
thing is that, my lord, they are saying that they have some difficulty, but the
No,
thing is, I'm
actually-
going to retire March, my lord.
Oh,
My pay is some short date, my lord.
December.
December, first week, my lord. Can you?
First week we are not here. Second week.
16.
Or first week. First week. Yes, first week.
Well,
6th of December,
6th December.
2nd of December, sorry.
As prayed for on behalf of the respondent and agreed to by the appellant. Let this matter come up for consideration.
On 4th of December, my lord. 4th of December.
4th of December.
4th of December.
Oh, like,
Please stop.